In your Telegram group, I have sent 3 PDF. In your Telegram group, first PDF is a combined PDF for lesson 2 of company law and lesson 2 of SBILL. Okay. So basically, lesson 2 of company law also talks about types of companies, and lesson 2 of SBILL also talks about types of companies and incorporation. So combined notes I have made for this notes is applicable for lesson 2 of company law also, and lesson 2 of SBILL also. Incorporation topic is also there, and you have to prepare this for both the examinations, CLAW examinations also, SBILL examination also. Also, one more thing, the lesson 1 of company law that we did, basic features of company law, remember, corporate personality, limited liability, perpetual succession. So that lesson 1 of company law you have to study also for SBILL, that features of company, uh, that will also be covered in SBILL. Okay, so lesson 1 of company law and lesson 2 of company law, that you have to study for SBILL also. And the second PDF is of MOA part 1, where you can see the basic introduction of MOA and about the name clause and about the registered office clause that we did yesterday. Okay, so 2-3 clauses are not there which are in material in single pointers only. So I have written that those topic you can do from material, and those lengthy topics are covered here, like name clause, registered office clause is given in the notes. Liability clause, capital clause is only two topics, small topics, so that you can do from the material, because in material only that topic is given in a very small and pointers manner. So, and the third PDF that I've sent is alteration of MOA and AOA. Alteration of MOA and AOA, in this all the alteration of all the clauses of MOA is covered, and alteration of AOA is covered. Acha, this is not complete MOA AOA chapter, only two topics are covered. First, basic about MOA, and alteration of MOA and AOA. So the remaining topic as we will do, and then we will cover that from the notes also. Okay. Okay. Now what you have to do, you have to today after going home, you have to note it down in your notebook. In company law, uh, lesson 1 notes also I'll share. So first complete the lesson 1 notes of company law. Lesson 2 I've already shared, and then this CLAW SBILL lesson 2 notes now you can write in company law notebook only. No need to write in SBILL notebook. This lesson 2 notes you can write in company law notebook only, and then you write lesson 3 notes MOA and AOA. I will check your notebook. You have to write everything in your notebook. Are we clear with this? You Okay, you have to write all the notes in your notebook and complete. Don't do from the PDF. From examination, complete. Either get the printout if you have so much money, or write it down and come. Okay, either get the printout or write it down and come. Everyone clear? Okay. Yes, thank you so much. Suddenly it started raining on Sunday. So Sky is also saying, don't study, don't go to the coaching. I will rain, I will cry. But so dedicated students came while it's raining. Very nice. Is it your first day? Third day? Oh, okay. So, guys, notes, although I have sent the notes, but studying only from the notes is not sufficient. it might be possible that by mistake I have left few topics to cover in the notes, so please cross check from the material if any topic is missed in the notes. वैसे तो I have tried to include all the topics there, but if by chance any topic is there in the material which is not there in the notes, then please do cross check, and if any topic is not covered, then you cover it from the material. Are we clear with this, everyone? Okay. Yes. Dear online students, let me know in the chat box if I am properly visible and audible to all of you. Online students, yes, online students, all the online students, just drop a message in the chat box. Okay, so we will just quickly revise about MOA and AOA that we did yesterday. It is known as Chennai Express revision, like a quick and super fast revision so that you get idea. Okay, so first we started with MOA and AOA lesson. So MOA is defined in section 2 clause 56 of the Companies Act 2013, which says that memorandum means memorandum of association as originally framed or altered from time to time. After that we did meaning of MOA. MOA is a legal document which describes the object of the company. What else? It defines the purpose of the company uh, and the scope of operation of the company beyond which the actions of company cannot go. And if a company does anything which is beyond the object of MOA, then it is known as ultra virus and null and void. See, whatever I remember, I'm just framing the sentence on my own. It is not necessary that you have to write as it is, but make sure that your English is correct, your English is understandable. It should not change the meaning of the sentence, the crux of the sentence, and some legal words like object, purpose, ultravirus, void. That legal words should be there. That those legal words should be there. Language should be proper. Otherwise, the full sentence you can frame on your own. Are we clear with this, everyone? After that, we did. What is the section of MOA? Section Section 4 of MOA, which says that every company should adopt. Is it compulsory to adopt any one of the table, any one of the model MOA? Yes. So Section 4 says that it is compulsory every company should adopt the model MOA mentioned in table A to table G as may be applicable. So to which company which table is applicable? Limited by shares A, limited by guarantee not having share capital B, limited by guarantee having share capital C, unlimited not having share capital D, and unlimited having share capital E. Are we clear with this? After that, we did clauses of MOA. There are 6 clauses in MOA. First one is the name clause, the situation or registered office clause, object clause, liability clause, capital clause, and subscription clause. And in case of OPC, one more succession clause is there which mentions the name of the nominee. Name clause includes the name of every company, and the name of a public company should end with the word limited, and name of a private company should end with the word private limited. Government company's name can end with the word limited even if it is a private company, and section company Section 8 company name need not include the word limited or private limited. We studied some rules regarding the name of the company. That name of the company should not be identical or resemble too nearly to the name of existing company or any name of existing trademark. After that, we studied your name should not be undesirable. Your name, yes, your name should not be misleading or offensive to a particular section of people, to a particular group of people. And yes, if your name contains any of the word and expression which indicates some relationship with central government or state government or local authority, then prior approval of central government is needed. For example, India, Bharat, Prime Minister, Chief Minister, court, bureau, authority, panchayat, municipality, what else? Rashtrapati, President, Governor, etc. etc. Okay, that list is given in the notes. Notes I have shared with you. And thereafter, we did, when do we say that two names are identical and similar? If the only difference is, let's say, case, punctuation, spacing, tense, singular, plural, misspelled, translation in Hindi, English, yes, etc. Basically, this you can understand. If case law question will come, you'll be able to analyze whether these two names are similar or not. And basically, also, if the only difference is the word private or limited, or or sorry, private limited or producer limited, needy limited, etc., or if the only difference is these words, then also these two names are considered as similar or resemble too nearly to each other. That's it we did about the name. Now thereafter, how you can apply for the name? You can apply for the name through Spice Plus Part A, and ROC may reserve it for 20 days. However, if you want to change the name of the existing company, then you may apply through Run, and ROC may reserve it for 60 days. You are able to remember this 20 days and 60 days. Acha, just like this, many days limit will come now. So keep on remembering. ROC, this is for 20 days and 60 days. Okay. After that, your name should not be prohibited under Emblems and Name Prevention of Improper Use Act 1950. Your name should not be merely descriptive name, etc. Okay, after that we did the second clause, that is the registered office or the situation clause. It mentions only the state, name of the state in which the company is incorporated. And there is one more section regarding registered office, section 12. Section 12 says that every company should have a registered office and should verify the registered office with ROC within 30 days of the incorporation. How we will verify registered office with ROC? By filing a form which is known as INC 2222. Okay. And acha, one more thing, when we incorporate a company, we give a temporary address, like temporarily where you can communicate with us. That is known as correspondence address. Remember, during incorporation, we studied we have to give a correspondence address to ROC. Correspondence means temporary address. As of now, what is the address to which you can communicate? So during incorporation, now we already gave correspondence address to ROC. Now, if we are using the same correspondence address as a registered office, then we don't need to file INC 22 again. What did I say? We have to basically register our address with ROC. We have to tell our registered office ka address proper, what is the location. We have to give the address to ROC. While in corporation, now we give a temporary address, correspondence address, where government can communicate with us. We give correspondence address to ROC. So don't you think that correspondence address is already in the records of ROC? Now, if you will use, let's say, some other address as your permanent registered office, then again you have to verify that registered office with ROC by filing a form INC 22. However, if you will use the same correspondence address as your registered office, then ROC already have that address, so you don't need to file again INC 22, and you don't need to get it again registered with the, again verified with the ROC, because it is already verified. Are we clear with this? So see, INC 22 is not required if company's registered office is same as the correspondence address. Thereafter, we did a chodu sa topic that after outside every office and premise, we have to publish the name and address of the company in legible letters in conspicuous position in two languages, English and local languages. Thereafter, in every letters, in every documents, in every letterhead, bills, notices, in every publication of the company, we have to mention name, address, phone number, fax number, email ID, website ID, all this thing in English and in local language. In case of change of name, along with the current name, we also have to display the old name for like 2 years. And in website also, if a company has website, in website also we have to display all the name, address, SIN number, telephone number, fax number, all the details in English and in local language. After registered office, we did object clause. Object clause contains the object of the company with which the company is formed. It defines the scope of operation of the company, and it tells positively that the what activities can be done by the company and what activities cannot be done by the company. Are we clear with this? Objects. Thereafter, we did liability clause. It tells whether the liability of members limited by shares or limited by guarantee or unlimited. Then there comes capital clause. It is there only in case of only in which company? Only company having share capital. Only in case of company having share capital, then only there will be capital clause. It tells you the maximum capital that can be raised by a company, and it is the capital which the company is registered divided into number of shares and face value each. If there is preference shares, then separately the authorized capital of equity shares and preference shares will be mentioned separately. Thereafter, we did the subscription clause. In subscription clause, the subscribers to the memorandum agree to form a company, and they agree to purchase the shares of the company, which is those number of shares which is given opposite to their names. Are we clear with this? And after the company will be formed, then that number of shares will be issued to those subscribers, and they will become the first shareholders of the company. And these subscribers, they sign the MOA. They sign the MOA along with two witnesses, with the signature of two witnesses. And we also mention the designation of the subscriber, address of the subscriber, etc. Are we clear with this, everyone? Yes. Achha, in private company, minimum how many subscribers should be there? Two. In public if you want to incorporate a public company, then minimum how many subscribers should be there? Seven. Very nice, very nice, very good. So after that, in case of OPC, there is succession clause also, which tells you the name of the nominee who will become the subscriber in the event of the death of the sole member of the company. Sorry, who will become the member in case of the death of the sole member of the company. That's all we did about all the clauses. Thereafter, we started with alteration, right? All the topic done now. Now we have to start with alteration. So the first alteration that we started is name clause. Guys, first of all, there are 6 clauses in MOA. Can you name them? Name, situation, object, liability, capital, subscription. Can we alter subscription clause? No, because it is already done in the past. Now you cannot change it. Remaining 5 clauses. Can you alter these 5 clauses? Yes. But remember, for alteration of name, situation, registered office, and liability, Section 13 will be applicable. Section 13 talks about alteration of MOA. But for the alteration of capital clause, Section 61 will be applicable, which we will study in share capital chapter. Because it is capital now. Oh, logic. Capital, so it is given in share capital chapter. Are you understanding? Capital clause, you can use this memory technique so that you don't forget. The capital clause, it talks about share capital now. Capital clause talks about share capital. That is why it is covered in share capital chapter. So it is discussed in section 61. Okay. And rest all 4 alterations are covered in section 13. Okay, everyone. Now section 13 says that whenever you want to alter MOA, you need to pass special resolution. Which approval you need for altering MOA? Special resolution. But section 61 says that for altering the capital clause, you need ordinary resolution. That means majority approval is enough. You don't need 75% approval. Are we clear with this? Yes. Okay. So we know one thing, ki for alteration of MOA, we need special resolution. Now one by one we'll be doing each clause alteration. Yesterday we completed name clause alteration. In order to alter the name clause, it is discussed in section 13 subsection 2 and section 13 subsection 3. It says that if you want to alter the name clause, then you need the approval of special resolution and approval of ROC, that is central government. You need approval of central government. 2 approvals you need. Please remember, what approval do you need to alter the name clause? To alter the name clause, you need shareholders approval also by way of special resolution, and you need central government approval also. That means ROC approval. Central government have delegated that power to ROC. Now detailed procedure, proper step-by-step procedure, step-by-step procedure. First, we will call a board meeting. We will pass PR for applying to ROC, and their board of directors will authorize a particular director or a company secretary to make an application to ROC. Now we will make an application to ROC by filing a form which is known as run reserve unique name. If your name is as per the law, if ROC is satisfied that the name is appropriate and it is not similar to any existing company's name, then ROC will reserve your name for like 60 days. So here you have taken ROC's approval. ROC's approval taken? Yes. Now you need shareholders approval. In order to take shareholders approval by way of SR, you need to call general meeting, and in order to call general meeting, you need to call board meeting again. Whenever we have to call general meeting, you need to call board meeting. Are you understanding? Because who will do the management? Who will call the meeting? Who will organize the meeting? Board of directors only, now. So they have to do meeting. Are you understanding? Just like a wedding, like your parents will organize your wedding. Are you understanding? So your parents will do a meeting. Then only they will be able to organize your wedding. Organizing a wedding is a big task. It takes months to plan a wedding. Months. Some people start planning a year before. Yes, similarly, general meeting is so complicated, it takes months to plan a general meeting, especially annual general meeting. Preparation in a company starts 2, 3 months back, 6 months back to host or organize a general meeting. So who exactly organize and manage and call all this general meeting? Board of directors. So don't you think whenever we have to call general meeting, we need to call a board meeting so that board of directors can prepare for the general meeting? They can fix the venue, they can fix the day, date, time, place of the meeting, and they can decide everything. They can authorize a director or company secretary and delegate him the responsibility of calling the general meeting and issuing the notice. Yesterday I told you we have to give invitation to everyone. Wedding ka invitation you give, na, come to my wedding. Similarly, you have to give notice to all the shareholders, come to the meeting, come to the meeting, come to the meeting. So that is why the next step is we have to call a board meeting so that we can pass BR to fix the day, date, time, place of the general meeting, to authorize the director or company secretary to issue notice, to approve the notice, etc. To do all the work relating to calling general meeting. Now finally we will issue the notice of extraordinary general meeting, and then we will hold the meeting. In the meeting we will do voting and we will pass special resolution. Acha, if special resolution is not passed, then name cannot be changed. If special resolution is passed, then now we got the shareholders approval. Now whenever we pass special resolution, we have to file a Fevicol form. MGT 14. MGT stands for management. MGT stands for management. It is from the management chapter. Okay, guys, whenever we pass special resolution, Fevicol, I call this Fevicol form. Fevicol, whenever SR, MGT 14. Okay, SR, MGT 14 will be there. Whenever there is a SR, there will be MGT 14. You cannot separate those two. As if these two are attached with Fevicol. Fevicol का जोड़ है, नहीं छूटेगा. So these two are attached with Fevicol. You cannot separate them. You cannot separate them. So whenever there will be SR, there will be MGT 14. So because you pass SR, now a company has to file special MGT 14 to ROC within how many days? Within 30 days of the incorporation. Now, don't you think we have to get the name change registered with ROC so that ROC will issue new certificate of incorporation? So to register the name change, we have to again apply to ROC in the form number INC 24 within again 30 days of ROC. That means within 30 days of SR. So within 30 days of SR, you have to file two forms to ROC, that is MGT 14 and INC 24, and then ROC will enter the new name in the register and will issue a fresh certificate of incorporation which will be in the form INC 25, and your new name will not be effective from the date of special resolution. Your new name will be effective when ROC registers the change and issues you new COI. That's all about the process of alteration of name clause. Acha, you don't need to take ROC approval or government approval the in case the alteration of name is only with respect to addition or deletion of the word private because of the conversion of private company to public company or public company to private company. Two companies are not allowed to change their name. Defaulter companies, basically, if a company has defaulted in filing annual return or financial statements, then that company will not be allowed to change its name. And number two, if a company has defaulted in the payment of deposit, debenture, or interest therein. But if later on they file the pending annual return financial statement and they repay all the debenture, deposit, interest, that means if they correct the default, then after that they will again be eligible to change their name. Okay, that's it. Have you read these four case laws? Were you able to understand? Pura, all? No, which one? Vardhaman one. Okay, we will discuss. Rest three, you were able to understand? Let's just read it very quickly. In the case of Atlas Cycle versus Atlas Products Limited, there was a two company, Atlas Cycle Haryana and Atlas Products Limited. Use the brand name as a corporate name. Use of the brand name as a corporate name was settled. Both the plaintiff and the defendant companies belong to the same family. Basically, they were from the same family, and they were using the same brand name, Atlas. So the appellant plaintiff was a proprietor of the trademark with the name Atlas. Who was the owner of this trademark Atlas? This appellant company, that means Atlas Cycle. He was the what owner of the trademark. This trademark belongs to Atlas Cycle. Now, what happened? The plaintiff was the proprietor of the trademark name Atlas. Respondent of the defendant company containing the name Atlas in its corporate name started dealing in bicycles. Okay. Now what happened? Please understand there are two companies. The name of one company is Atlas Cycle Haryana Limited, and the name of another company is Atlas Products Private Limited. Till now they are telling you the case law. So what happened? First, this Atlas trademark is registered by this company. So this first company has registered, is the owner of this trademark. Now what happened, this another company also started using the word Atlas in their name, and they also started making bicycles. Till now case is clear. Now what happened, the plaintiff objected to the use of the name Atlas by the defendant company. This Atlas Cycle said that you cannot use the Atlas name because it is our registered trademark, and the defendant was restrained from using the word Atlas in their trade name in respect of the bicycle. So it was said that since this company is dealing with cycle, so if this company will deal with any other product, then they can use the word Atlas. But if they want to sell bicycle only, that means same product, then for same product they cannot use the word Atlas. Otherwise, it will mislead the public. So court said that this Atlas Cycle will win the case, and court said that this Atlas product cannot use the word Atlas for selling bicycles because it is their registered trademark in the category of cycle. In the category of cycle and vehicle, you can say. Are we clear with this? Achha, trademark में there is one concept that you can trademark a particular name or whatever or mark only with respect to a particular category of goods. This you will study in trademark. Basically, what I mean to say is, let's say there is one category, there is a one category of VIP, VIP K suitcase and all these bags also come, and undergarments also come. VIP brand, have you heard? VIP brand, yes. So how come these two companies are having the same name, VIP? Why? Because one is dealing with another kind of products and one is dealing with another kind of product. So if let's say VIP, which is making suitcase, VIP company which is making suitcase and bags and all, they have registered their trademark only in that category. They have not registered their trademark in clothing or textile or these categories. Are you understanding? So that is why the another company was made VIP, which were making undergarments and all, because these two are in two separate categories. But in the same category, you cannot use the word, you cannot use the same trademark. Now you will say, ma'am, Reliance is not in education category. Can we make Reliance education? No. Why? Because these kind of big companies now, what they do, they register their trademark in all the categories so that no one, no one in no category they can copy the name. So these kind of big companies, those who get this much famous, those who get all over India famous or internationally famous, what they do, they get their trademark. Let's say Reliance is their trademark, so they get their trademark registered in all the category of goods and services so that no one will be able to copy this. So here what we said that ki if this company will start selling cycle, that means same category of product, then they cannot use the word endless, otherwise it will mislead the public. So here this will, when the case, this is the particular case. Second case is where a company is directed to change its name. The court cannot directly tell the registrar to effect the change in the name of the company. The court can only direct the company to do so. The company cannot simply file a court order regarding the change, but it will have to follow the prescribed procedure. This we will be studying today, that if central government asks a company to change its name, then central government cannot directly ask ROC to change the name. A central government will ask company to change its name. This process we will do today in section number 16. In section number 16, we'll be doing this today. Next is a person cannot be permitted to name a company even after his personal name if that name resembles the name of the existing company. So, for example, if let's say your name is Amul, then you will not be allowed to register a name even with your own name, because Amul is already a registered trademark and it is already a company, existing company. So are you understanding? You cannot say that no, 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 my name is Amul, so I will make a company with the name Amul. You cannot make here. Why? Because Amul is already a name of the existing company. So let's say if I want to make a company with the name Ishika Education Private Limited. So you know what? If already there is a company with the name Ishika Academy or Ishika Education, or there is already a company in the same category, in the education category, if already there is a company with the name Ishika, or you know this word is there, then I cannot make a company with that name. But if let's say there is no existing company with the name Ishika and in education category, are you understanding? Then I will ROC will allow me to register the company with my name. So if there is already a very famous company, let's say already with the name, let's say Ishika Academy Private Limited, now I cannot make that use that name even if my name is Ishika, because there is already an existing company with that name. Are you understanding? So here it is given that a person, like for example me, cannot be permitted to use the name of the company after his personal name. I cannot use Ishika Education if that name resembles to name of existing company. Okay, only if there is already existing company. So basically the crux is that if there is existing company with any name, then you will not be allowed to use that name, because the name will be similar and similar names are not allowed. That's why, you know, nowadays people are making coined names of the coined names means which does not have actual meaning, no dictionary word. They are just randomly making a new word. Ola, Uber, Zomato, Swiggy, these are coined names. They don't have any dictionary meaning. Zomato, what do you mean by Zomato? Swiggy, what do you mean by Swiggy? It's not an English word. It's not an English word. Okay. So people are making coined names. Ola. What is Ola? Ole, 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 ole. Ola means it is an English word. It is Latin word, na? हाँ तो मतलब see, we are taking words from different Latin languages and all. Basically, it's not an English word. And there are, if you will see Shark Tank now, nowadays people are making very unique name for their startups. Like one in last season, season 3, when Bihari came. One person from Bihar came, he made an app like Ola only, but only for Bihar. If you have seen that. Yes, the name of that brand was, is based on local auto and local passengers, so that you get the two-way passengers. The name of that company was Road Base. It's not a word. How they use that word, because roadways. So people in Bihar, na, they pronounce roadways as road page, road base, like this. So that's how they named this company Road Base, because the pronunciation is similar to roadways. But actually, if you see RODBEZ, it is not a dictionary word. So they just invented this new word as a trademark or as their business name. So people are doing this. Why? Because almost all the names are already taken, So now people are inventing new name for their business. Okay. Now come here. Sweetie. It's an English word, yeah? Kannada now, not in English now, because they don't know Kannada, right? Those who have those. Swiggy is the Karnataka. Oh, yes, yes, yes. Yes. So, see, English may it is not having the meaning. It might be possible that in some other languages it means, what does it mean again? Swiggy means? Harvesting. Okay, okay, okay. Got it. Got it. So if there are many other words also which does not have literally a meaning and people are just inventing or making a word on their own, or which is not having the meaning in common language like English. We and some people also make a company, take the Japanese name. They name their company in some Japanese word. Can example? What city is that? Yes, Esther. Okay. Katana. What does it mean? Sports. It is a sword. Oh, it is a Japanese word. Oh, you know Japanese? Oh, हाँ. Okay. ठीक है. Coming back to the topic, the last case law, in the reference Vardhaman Crop Nutrients Limited versus Union of India, High Court of Punjab and Haryana. Brand name Vardhaman was a guys. Read here. Brand name Vardhaman was already registered trademark of a respondent company. Respondent company means the company against whom case was filed, which is Vardhaman Fertilizers and Seed Limited. Okay, so there is a company named Vardhaman Fertilizers and Seed Private Limited. That company was already that company registered trademark Vardhaman. They are using Vardhaman as their trademark. They have registered it in their name. Okay, they have registered Vardhaman trademark in their name. And both appellant is Vardhaman Crop Nutrients Private Limited. Okay, so there is one appellant company which is Vardhaman Crop Nutrients Private Limited, and there is one respondent company which is Vardhaman Fertilizers and Seed Private Limited. But this trademark Vardhaman is registered with whom? This trademark Vardhaman is registered with Vardhaman Fertilizers and Seed Private Limited. Now, and the respondent companies are doing the same business. What is the problem? Both the companies are doing same business and they are using the same brand name Vardhaman. So the respondent company filed an application under Section 222 seeking direction to appellant company to change or delete the name brand Vardhaman, the registered trademark of the respondent company, as the same was undesirable and causing great loss to the business, reputation, and goodwill of the company. And the appellant company, on merits, it was held that the appeal was dismissed and the appellant company was granted 3 months' time from the date of receipt of the copy to change its name and delete the word Vardhaman from their existing name. So please understand what's happening. There is a company of Vardhaman Fertilizers and Seed Private Limited, and there is a company called Vardhaman Crop Nutrients Private Limited. Okay. Now what happened? Both this company are using the same trademark, that is Vardhaman. But the question is, who has registered the trademark? The person who has registered the trademark Vardhaman will win. So this company Fertilizers and Seed, they have registered trademark of Vardhaman. Yes, you are the model 1 student, so you have already studied trademark in very detail. That the person who has registered the trademark in their name, they have all the rights for using that particular name. So here in this particular trademark Vardhaman is registered by Vardhaman Fertilizers and Seed. Now, please understand, these two companies are not engaged in different categories. Both are engaged in similar category only, like relating to agriculture, fertilizer, seed, crop, etc. Relating to all this only. Now, so both are in working in same category. So if they are working in same category, their business is in same category, then they cannot use the same trademark. Otherwise, it will mislead the public. So here, who will win? Who will be allowed to use this name? Vardhaman Fertilizers and Seed. Why? Because they are the registered owner. So again, here also we are talking about section 16, where if someone copies your name, then you can request central government. Central government ask this company to change its name. Ask this company to change its name. They copied my name, and then central government will order this another company, Vardhaman Crop Nutrients, to change their name within 3 months. This we will study again in section 16. So basically, this last case law and the second case law both are talking about section 16 that we will study now. Basically, are we clear with this? Were you able to analyze this on your own when you read it, when you read these provisions? Very good. Those who have not read it only, very bad. And those who have read it and come, even if you don't understand, then also well and good. Now please come here to the Okay. Please come to the page number 6060. Please come to the page number 6060. Please come to page number 6060. Can you see here one paragraph of section 16? This paragraph which is remaining to be discussed, section 16, and there is one more point about section 16. Only one para about section 16. Okay. So for this here write read notes. Section 16 के लिए write here read notes. Okay. Now section 16 talks about rectification of name or change of name of the company by order of central government. By order of central government. So it might happen sometimes that let's say we have registered a company with the name Yeshas Academy Private Limited. We have registered a company with the name Yeshas Academy Private Limited. When, let's say 20 years back. 20 years back, we have registered a company with the name Yeshas Academy Private Limited. If today someone will start a company with the same name, someone else started a company with the same name, Yeshas Educations Private Limited, or let's say Yeshas Institution Private Limited, in the same category, education category. The question is, first of all, the ROC will not register that name only because that name is similar now, guys. If we have already registered Yeshas Academy Private Limited, ROC will not allow someone else to register the company with the same trademark, with the same brand name, and in the same category. If they want to use the word Yeshas for, let's say, selling clothes, ROC might allow because clothing is a different category and education is a different category. So if someone wants to start a, let's say, clothing brand, Yeshas Clothing Private Limited, ROC may allow because these are different categories. But if someone wants to use the word Yeshas in education only, Yeshas Institution Private Limited, they want to register. First of all, ROC will disallow that name. ROC will not reserve that name and will reject that name because that name is similar to the name of our existing company. But sometimes it might be possible that ROC miss out and let's say ROC registered, ROC did not notice by mistake. ROC, there is someone human being only who is sitting there and doing the work of ROC. So it might be possible that let's say ROC registered that company. But now, who is in grievance? Yeshas Academy. We are in grievance that we are running Yeshas Academy since like 20 years and someone came today and copied our name. Don't you think they will use our goodwill of 20 years? They will use our goodwill now, whatever brand name, whatever goodwill we have developed, they will use our goodwill. So someone came and used our word, Yeshas Institution Private Limited. So we are aggrieved here. We have genuine problem because someone is copying our name. So there should be some provision of complaining. There should be some provision of complaining now. You can go and complain to your parents. See, my sister is slapping me. If a fight happens between brother and sister, you go and complain to your parents. You do. Girls, you do complain about your brothers to your parents? No, you don't. So good. I to complain about my brother. Even if I slap him, I'll be like, Dad, he slapped me. So like that only. So the point is, if someone copies our name, we are the existing company, and if someone registers a company with the same name or with the same trademark, with the same name of the name of existing company or with the same trademark, in that particular case, there is a provision that we can go and cry in front of central government. We can make an application to central government and we can complain this to central government. But we have to complain within 3 years. Let's say if someone made a company today, 1st January 2025, then we have this right to make a complaint only within 3 years, that is till 1st January 2026, 2027 and 2028. After that, we will lose our right to make this complaint. Okay, so we have to make a complaint to central government within 3 years. And if the owner of the existing company or the registered trademark makes an application to central government about that someone copied our name, then central government will order that person to change its name within 3 months. This is a process of change of name by the order of FCLT. Are you understanding? So if let's say we have opened here Yeshas Academy since like 20 years back and we have a registered trademark. Some Mr. A, some Mr. A started a Yeshas Educations today. Then we can make an application to central government. We will say central government, see this Mr. A started Yeshas Education, which they copied our trademark. They are using copying our name of existing company. So we will make application to central government within 3 years, and then central government will direct and order that Mr. A. Central government will order Mr. A and that company, Yeshas Education company, you change your name. Change your name is similar to the name of existing company or existing trademark. So Yeshas Academy will order that person to change its name, and they have to change their name within 3 months. Are we clear with this? So it is like central government is ordering you to change your name, so you have to compulsory change your name. What process we did yesterday was a voluntary change of name. We voluntarily want to change our name. We voluntarily want to change our name from XYZ to ABC. So that was the procedure. Section 16 talks about rectification of name, that if your name is similar to the name of existing company or existing trademark, then the owner of the registered owner of the trademark or the existing company can make an application to central government, and central government will order the company to change its name within 3 months. Are we clear with this? Acha. In yesterday, the process that we did yesterday, voluntary change of name. What approvals do we need for that? What approvals do we need for that? We need shareholders approval and ROC approval. Shareholders approval by way of special resolution. That means 75% approval, because that was voluntary change of name. So if you're voluntarily you want to change your name, then make sure it is approved by at least 75% of the shareholders in a paid up share capital. But if central government is ordering you change your name, then you don't have choice. You don't have choice. You have to change your name because central government is saying, you cannot disobey central government. So if central government will order you to change your name, then you need to pass only OR. SR is not required. Are you understanding? You just need majority approval. So you will take the majority approval, more than 50% approval, and thereafter you will change your name. But you have to do this within 3 months. What if you don't do within 3 months? What if you don't change your name within 3 months? Then central government will say, no, not strike off. No, not wind up. Not penalty. Penalty will be there, but yes, no, not extend the time period. Yes, central government will change the name. Central government will be like Atta Maji Satakli. Central government, central government will be like, either you change your name or I will change your name. It's like either you go out on its own or I will throw you out of the classroom. Like that. Central government will say, either पहले तो we are talking सीधा सीधा, you change your name इज्जत से. If not, then we will change your name. And when we will change your name, we will give you such a vahiyat name that you will cry. We will give you Ramesh. We will give you name Ramesh. Are you understanding? So here central government will say, we are giving you chance 3 months time. We are giving you 3 months time. You change your name on your own, and you can keep any other name, whatever you like. But if you don't change your name in 3 months, then we will change your name, and your new name will be Vahiyat. The new name that we will give you will be Vahiyat. So if you don't want that Ghatiya name, how do we say Ghatiya in Kannada? Ghatiya means worst. No, in Kannada. Vichitra. Kachra. Kasa. Kachada. Kachada means worst. Kachada means worst. And in Hindi, Kachada means garbage. That's kachra. Kachada. Kachada means worst. Okay. We will give you kachada name. Okay. So we will give you such a kachada name that you will cry. Now come here. Section number 16. Rectification of name. Section number 16. Rectification of name. Acha, wait. If someone copies the name of the existing trademark, existing company, then the owner of existing trademark can also apply to central government. Also, if central government voluntarily notice it, then central government can itself, even if the owner will not make application to central government, if central government itself notice it, then central government can itself also order the new company to change its name. Are you understanding? Let's say we are Yeshas Academy. There is some newcomer who copied our name. So even we can also apply to central government within 3 years, and then central government will order that new company to change its name from Yeshas Academy to something else. Or let's say if we have not applied and it came to the notice of central government only, then central government can itself also make an application to make an order to that new company to change its name. Okay, so in two situation, everyone come here, rectification of name, section 16. If in the opinion of central government, if in the opinion of central government, that means we have not applied, existing owner have not applied, central government itself is of opinion that they copied our name, so central government will order that company to change its name. Okay, so if in the opinion of central government, power delegated to RD, in bracket RD means original power is with central government, but central government has delegated this power to RD. So who can do this name change? Order to change the name? RD. Who will order you to change your name? RD. RD means regional director. So if in the opinion of central government or on the application made to central government by the registered trademark owner or company within 3 years, not 3 months, 3 years, within 3 years, within 3 years of the incorporation of the new company. Okay, 3 years, yes, 3 months, 3 months may you have to change the name. 3 years may original owner can make an application, and then central government will order the new company to change its name, and then that new company will get 3 months to change the name. You got the difference? Where is 3 years and where is 3 months? Okay, so here either central government in its own opinion, central government means RD, or on the application made by the registered owner of the trademark or registered owner of the company within 3 years. If the name of any company, if the name of any company is identical or resemble too nearly to the name of another company or trademark. Okay, so if the name of any company is identical or resemble too nearly to the name of any other company or trademark, then central government will direct that company to change its name. Direct means order. Direct means order. Central government will order that new company. Change your name, change your name. Your name is similar to the name of existing company or the name of existing trademark. Okay? Yes. Now, company has to change its name within 3 months by passing OR. Now, guys, please understand. In the normal voluntary name change, we have to take 75% approval. But if central government is ordering us to change the name, then we don't need 75% approval. We don't need to pass SR. We only need to pass OR. OR means ordinary resolution. Then we can change our name within 3 months by passing ordinary resolution. Now, do you remember yesterday's process of voluntary name change? There we studied when we change our name. Don't you think we have to get our new name registered by ROC and get a new COI? Guys, yes or no? Yes, we have to get our new name registered with ROC. So now we changed our name. Central government gave us order to change the name and we changed our name. Now we have to apply to ROC now. We have to inform ROC, possessive boyfriend. We have to inform ROC, ROC, we changed our name. Now you register the new name in the register and issue new certificate of incorporation. So now after we change our name by passing special resolution, we will give the notice of such change of name and order of central government to ROC in the filing which form INC 24. For the name change now, we always apply to ROC in the form number INC 24. But here the time limit is 15 days. Normally the time limit was 30 days, but here the time limit is 15 days. Acha, along with this, we have to give a copy of notice of order of central government. Obviously, if central government ordered us to change its name, central government will not call us and order us. Central government will issue us a written notice, written order. Central government will send us a written order to change our name. that copy of order of central government also, Xerox copy of that order of central government also we have to file to ROC along with the form number INC 24. Are we clear with this? As a proof that see, I got this order from central government. Are you understanding? So that copy of that document also you have to file to ROC. Okay, everyone. So you have to give the notice of change, plus you have to send the order of central government, copy of order of central government, and you have to file it to ROC in the form number INC 24 within 15 days of the change. Now ROC will change the name in the new register, will enter the new name, and will issue fresh certificate of incorporation in the form number INC 25. Shame. This is shame to shame. This is also same. The only difference is here the time limit is 15 days. But now what line will come? If company does not change the name within 3 months, then RD will itself change the name and will give any Vahiyat name, Kachada name. Are we clear with this? Now come here. If company defaults means company does not pass this ordinary resolution and company does not changes the name. Except when INC 24 is pending for disposal. What do you mean by except for INC 24 is pending for disposal? Except, let's say it is in the process, yes. Except when we have changed the name, we have passed ordinary resolution, and we have filed INC 24 also. ROC is left to register. In that case, RD will not change our name. If we have done everything within 3 months, guys, we have passed ordinary resolution also, and we have changed our name also, and we have filed INC 24 to ROC also. It's just that ROC have not yet registered our new name. In that case, RD will not give us punishment. RD will not give us punishment because everything is done from our end. But if you don't even pass OR and if you don't even change your name, then automatically central government, here central government means RD. Automatically RD will allot the new name of the company, and that new name will be, your new name will be letters ORDNC. ORD stands for ORDNC. ORDNC. RD stands for regional director. ORD stands for order of regional director not complied. They are giving you a defaulter tag in your name. Your name is ORDNC. ORDNC stands for order of regional director not complied. Anyone who will read the name of the company will get to know ye to defaulter company. This is defaulter company. Name will be ORDNC plus year of passing direction. Let's say central government gave us order in 2025. So your name will be ORDNC 225. Any serial number will be unique for every cases and existing SIN number of the company. This is going to be your new name. Of the company. ORDNC 2025 12345 and then existing SIN. Basically ORDNC plus year of passing direction by central government, serial number plus existing SIN. Are we clear with this? Now, don't you think now your name is changed? You don't even need to pass ordinary resolution. Central government changed your name forcefully. Central government is like, either you change your name Ijjat se, or we will forcefully change your name. Okay, so here central government forcefully changed your name. So now don't you think name to changed? Now you have to tell your possessive boyfriend. You have to tell now. You have to tell ROC. Our name is changed. Now you enter the new name in the register of company and give us new certificate of incorporation with our new beautiful name. Okay. Now ROC will change the name of the company and will issue fresh certificate of incorporation, and this fresh certificate of incorporation will be in the form number INC 11C. Okay, understood till now? Now one more thing, one question to you. Now let's say our name is changed to ORDNC Phalana Dikhna, etc. Now is our name still similar to that existing company or existing trademark? No. So now are we in non-compliance? No na. So basically Why central government ordered us to change our name? Because our name was similar or identical to existing company or existing trademark. But now to central government change our name, ORDNC and then dash 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 dash. So now our name is not similar or not identical to name of any company. The question is, we have to live with this name for lifetime. That company whose name is changed by central government ORDNC dash 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 dash. Do we have to live with that name for lifetime? Or if later on again we want to alter the name, then again we can alter the name by following that voluntary procedure of alteration of name. Apply your common sense and say yes or no. Say any answer. Right, wrong, any answer. Yes, they can change. Yes. So the point is that you don't have to die with this name. Otherwise, next day only you will die. I don't want to live with this name, Ramesh. Next day only. So the point is, of course, so now basically you already got the punishment for copying someone's name. So it's not so serious default that we will ask you to lifetime live with this name. No. If later on again you want to change your name, then you can follow this procedure. Which procedure? This procedure, normal procedure of alteration of name clause, and by following the procedure of alteration of name clause you can again change your name. But now make sure that your name is not identical or similar to any name of existing company, and that's all about the rectification of name. This process is not given in your material, so this you have to do from your notes. This PDF is already sent in the group. Everyone okay? Yes. So very quickly I just read again. Rectification of name talks about section 16. Section 16 says that if either in the opinion of central government, that is RD, this rectification order is given by RD, power is with regional director, or if application is made by the owner of any registered trademark or company within 3 years. If they are of the opinion that any company is having the name of a company is identical or resemble too nearly to the name of existing company. This word try to write as it is, identical or resemble too nearly to the name of existing company. Then central government will order that company to change its name, and they have to change the name and by passing OR within 3 months, and apply to ROC with the copy of order of central government in form number IC 24 within 15 days, and ROC will register the new name and will issue a fresh COI in the form number INC 25. However, wait, did I mention this correct? No, na. Company has to, after changing the name, company has to apply to ROC in the form number INC 24 within 15 days. If by mistake I mentioned wrong. Now, if the company defaults in company does not change the name within 3 months, except if name is changed, only INC 24 is pending approval by ROC. And if company has not changed the name within 3 months, then central government, that is RD, will allot the new name, and the new name will be ORDNC plus year of passing direction plus serial number plus existing SIN. And then ROC will change the name of the company and will issue fresh certificate of incorporation in the form number INC 11C. And then now if company further wants to change its name, then company can again change its name by following the procedure of alteration of the name clause. Now guys, one more point I missed to mention. Wherever the name of the company is print, affixed or engraved, remember we discussed yesterday that we have to display the name of the company outside every office, in every bills, letterhead, every document, in the website. Everywhere we have to publish the name of the company now. So everywhere, wherever you have to publish the name of the company, in big words you have to write, above the name of the company or below the name of the company you have to write order of regional director not complied, so that everyone will get to know ki, oh, this is a defaulter company, this company has not complied with the order of RD. So here one point is given that wherever the name of the company is printed, affixed or engraved, the words order of RD not complied should be mentioned in the brackets below the name. After you will write the name, below the name in brackets you have to write order of regional director not complied. Arth aita everyone, easy peasy. So that is why in your material you will see in this topic of alteration of name, in the name of change of name, you are seeing two topics. There are two provisions for change of name. One is your change of name at the instance of company. Instance means desire of company. At the desire of the company means we voluntarily want to change our name. Okay, so this is covered in section 13 subsection 2 and section 13 subsection 3. which we discussed yesterday, and today we have revised that. And another topic is change of name on the order of central government. Central government power delegated to RD, and this is covered in section 16. So we are successfully done with this also, this also. In material, it is not given, the whole process is not given, only introduction about section 16 is given. So this process you can do from the notes. Okay, this process is not given completely in the material, so this process you can do from notes. Okay, so whenever you will read, now read book and notes simultaneously. Don't read only material or don't read only notes, read both of them simultaneously. Procedure of name change is already done. Guys, we will do this. Read this two lines, these two lines. Read this and these two cases very quickly and let me know who will explain. Even if in your own words, these two lines and these two cases, read very quickly. Done. So tell me, if we change the name of the company, does it mean that the old company has died and the new company has come into existence? No, we have changed the name. It doesn't mean that the old company has ended and the new company has come to existence. The old company is still continuing, only the name is changed. Acha, if there is any pending court case going on in the old name, if there is any pending court case going on in the old name, can we continue it in the old name or do we have to change it in the new name? Everyone, we can change it in the new name, but if you want, we can continue it in old name also. One point, guys, let's say if any pending court case is going on, and you know in India court cases go on for years and years, like years, it might be possible that that case will be disposed of after 5 years, after 6 years, after 10 years. So let's say in the meantime, that case is going on in the court, and in the meantime, name of our company changed. In that particular case, that old case, if you want, you can continue it in the old name, or if you want, you can change it to the new name. Now, let's say after the name is changed. After that, if you want to start a fresh litigation or if you want to file a case, now a new legal proceeding has to start. Then can it start in old name or it has to start in new name? Pretty logical कि after the name is changed, now onwards if any legal proceeding has to start, that has to be started in the new name. So what is the effect of the name change? Please read here. The change of name shall have no rights and obligations on the company or render defective any legal proceeding against by it. Here one point is given. If our name is changed, it does not mean that all the legal proceeding against us will automatically close down. No, it will have no effect on the legal proceeding that is going on. That will still go on as it is. That will still go on as it is. It doesn't mean that our whatever case was going against us is now ended. No, it will go on. It will keep on going on. So the name change does not affect the validity of the legal proceeding that is going on. And any legal proceeding which might have continued or commenced by or against the company in the former name may be continued by or against the company in its new name. May means optional. May means optional. So here one point is given: if any legal proceeding is going on against the old name of the company and we have changed our name, then if we want, we can continue the legal proceeding now in the new name, or we can continue it in the old name also. Okay. Next, by the change of name, the constitution of company does not change. The existence of company does not change. Only thing is change of name. All the rights and obligation of the old company passes to the new company. Here one point is given: all the rights and obligations of the company will be same, or all the rights and obligations of the company will be same. Company will be same. Change of name does not mean that the old company is dead and the new company has come into existence. The old company is still continuing. So change of name does not mean change of constitution of the company. Only there is a change in name. This is the effect of change in name. Now what is given in this case law? There is one case law of reference, Malati Tea Syndicate Limited versus Revenue Officer, where a company changes its name and the new name has been registered. The commencing legal proceeding in the former name is not valid. What they're trying to say is, if we have already changed our name, now if new legal proceeding has to start, then new legal proceeding will start in the new name. It's now already name is changed, but old proceedings may continue in the old name or may shift to the new name. Next, in the case of reference, Pioneer Protective Glass Fiber Private Limited versus Fiber Glass Pilkington Limited. In spite of the change of name, the entity of company continues. The company is not dissolved, nor does any new company come into existence. What they are saying in this case, court established that if you change your name, it does not mean that the old company has discontinued or the old company has dissolved. The old company is not dissolved, neither a new company has come into existence. If any legal proceeding is commenced after the name change against the company in its old name, then company should be treated as if it is not in existence, and it will not be an incurable defect, as a plaintiff cannot amend and substitute the new name. What is given here, guys? Let's say our old name was ABC Private Limited. This is old name. Now we changed our name to XYZ Private Limited. This is new name. So first of all, court said that change of name, even if there's change of name, still the entity continues. It doesn't mean that the old company is dissolved. No, old company is not dissolved, and neither does the new company comes into existence. Okay. Now, after the name change, now if any new legal proceeding has to start, then it has to start with the new name, that is XYZ Private. However, let's say we have changed our name. Now this is no more our name. Now our name is XYZ. Now if anyone files a case in the old name, then it will be treated as if this company ABC Private Limited does not exist, because we have already changed our name. Now new legal proceeding has to start in the new name. And if someone still file a case, start legal proceeding against the company in the old name, then that petition will not be valid. It will be treated that this old company is already dead and not in existence. Everyone okay, understood? So this is your effect of change of name. And very quickly come here. See, this is not Companies Act. This is SEBI LODR regulations. Sometimes ICSI goes crazy. Ideally, they should not ask LODR regulation in company law, because LODR regulation is itself very complicated and very lengthy. Yes, you'll study that in module 2. LODR regulation is very lengthy and very complicated. But Companies Act and LODR are very much complementary to each other. SEBI regulations and Companies Act are complementary to each other. So, like if you're an unlisted company, then you only have to comply with Companies Act. However, if you're a listed company, then you have to comply with Companies Act also and SEBI LODR regulations also. So if you are a listed company, let's say you are Tata Consultancy, TCS. You are Tata Consultancy. So you are a listed company. TCS is a listed company, guys. Yes or no? Yes. TCS is a listed company. So if TCS want to change its name, then they have to comply with Companies Act also, and they have to comply with SEBI regulations also, because to listed companies, SEBI regulations are applicable. This much are you understanding? If there is a listed company. Acha guys, let's say if there is a private company, ABC Private Limited. Do they have to comply SEBI LODR regulations? No. SEBI regulations are only applicable for listed companies. SEBI regulations are not applicable for unlisted companies. So if there is unlisted company, private company, let's say ABC Private Limited, then that company don't have to follow SEBI LODR. We only have to follow Companies Act and companies rules. But if there is a listed company, TCS, Tata Consultancy Limited, Services Limited, TCS, then it's a listed company. So we have to comply with Companies Act also, and we have to comply with SEBI LODR also. So only for listed company, SEBI LODR is applicable. And when we change a name, when we change the name of a listed company, then we have to do some additional compliances as per SEBI LODR. We have to change our name by following Section 13 of the Companies Act. We have to follow Section 13 of the Companies Act. Along with that, there are some additional compliances given only for the name change of listed companies, which are given in SEBI LODR. Are we clear with the topic? So the topic is name change under Regulation 45 of SEBI LODR regulations. LODR stands for Listing Obligation and Disclosure Requirement. These are applicable only and only to listed companies. Now some additional compliances are there, that if a listed company wants to change their name, then they have to comply with the following condition. Number one, at least 1 year should have been elapsed from the date of last name change. That means you cannot change your name more than twice in a year. In a year, you can change your name only once. What is this key? Every day you are changing your name. It's not something which you should do every year. Name is something which you should stick for the lifetime. If you keep on changing your name, how will people come to know about your name particular? People will get confused. So here one point is given, key if you have changed your name in the last 1 year, then you will not be allowed to change your name again in this coming 1 year. In 1 year, you can change your name at least once. So a time period of at least 1 year should be completed after the last name change. So if you change your name now, then again you have to wait for 1 year to change your name again. Next is at least 50% of the total revenue in the last year should have accounted for by the new activity suggested by the new name. Let's say we are changing our business also, and that's why we are changing our name. So let's say we are changing our name from Yeshas Academy Limited to Yeshas Foods Private Limited. We are changing our business from, let's say, education to food. We are opening one more branch of Rameshwaram Cafe. Yes. So one branch is ours, if you know. It belongs to Yeshas Academy. Yes. So one branch of Rameshwaram. So if you will come here, at least let's say we are changing our business from education to food. So you are changing your name from, let's say, Yeshas Academy Private Limited to Yeshas Foods Private Limited. Okay. So in this case, if you're changing your name, which also suggests the change of name of business. So it suggests that earlier you were doing education business and now you're doing food business. So in that particular case, in the last 1 year, your revenue from the food business should be at least 50%. So it says that at least 50% of the total revenue means sales, not profit. Revenue means sales, turnover. So at least 50% of your total revenue in the last 1 year, at least 50% of the total revenue in the last 1 year should be accounted for the new activity, should be coming from the new activity. That is, let's say, food business. At least 50% of the income should come from food business if there is a change in activity in the name suggested by the new name. And the company should obtain auditor certificate to the stock exchange. If a listed company wants to change its name, then we have to take a certificate from our auditor. Auditor means statutory auditor who is chartered accountant in practice. He does the audit of financial statements, balance sheet P&L. Who check your balance sheet P&L? Who are expert in accounts? Auditors, CAs. So they act as a statutory auditors. So from your statutory auditor, who is basically CA in practice, so you have to take a certificate from your statutory auditor and you have to submit it to stock exchange, then only they will allow you to change your name. And the new name along with old name should be disclosed in the website for the continuous period of 1 year from the date of name change. In LODR it is mentioned 1 year, Companies Act it is mentioned 2 years, so you have to follow 2 years, whichever is more strict. So here, if when you change your name along with new name along with old name, you have to display for, in LODR it is mentioned 1 year, Companies Act it is mentioned 2 years in the website. That's all. This is more than enough. These are some additional compliances only for the listed company. These are not applicable for unlisted companies. Are we clear with this, everyone? This is not important. Method of changing the name, we'll just read it and then we'll cut it. After incorporation, company may change its name by following method. Don't underline. Conversion of private company to public company and thereby change of name from private to public. How you can change your name? If you're converting private company to public company, Zomato Private Limited to Zomato Limited, then you might want to change your name and delete the word private. Conversion of public company to private company and adding the word private. If you're converting public company to private company, Tata Sons Limited to Tata Sons Private Limited, then simply you will add the word private. Or simply you can change your name from one to another, like ABC Limited to XYZ Limited. Don't you think we already know this? And section 13 says that name of change shall be changed by passing special resolution of the members and with the approval of central government. But on the other hand, if the change relates to addition or deletion of the word private, then central government approval is not required. Everything is repeated. Kya? Cut it bada bada and write here repeated. Why we are cutting this? Because it is repeated. Everything is already covered. Repeated. Repeated. And guys, we'll be starting with alteration of situation or registered office clause. Basically, it is given in section 12 also and section 13 also. Section 12 talks about registered office and section 13 talks about alteration of MOA. Okay, yes, everyone. Okay, so now listen. When we talk about change of registered office, new topic, new topic, new topic, change of registered office. So everyone, when we talk about change of registered office means we are changing our address, we are changing our office address. When we talk about change of registered office, we are classifying it in four categories. Four category. First is if you're changing your address within the same city, town or village. See, every place is classified either as a city. If it is developed, then we call it city. If it is a little bit less developed, we call it town. And if it is a rural area, then we call it a village. Okay. So every place ko we will call either city, town, or village. So in short, I have written it CTV. CTV means city, town, or village. Okay. So first situation, very not very big matter. You are changing your registered office within the same city. That means, let's say our registered office is in Bangalore only. Our registered office is in Bangalore, and we are changing our registered office somewhere within the Bangalore. Somewhere within the Bangalore. Let's say from Jayanagar to JP Nagar. Are we clear with this? Or from, let's say, Jayanagar to Whitefield. Everyone okay? So this is your first situation. First situation, it is covered in section 12. If you want to change your registered office within the local limits of same city, town, or village. Local limits means you are not changing your address from one city to another. You are changing your registered office within your city, or within your town, or within your village. Okay. The second category is you are changing your city. You are changing from one city to another. For example, our registered office is in Bangalore. From Bangalore, we are shifting it to Mysore, let's say. So here, Mysore is a different city. Bangalore is a different city. So we are changing our registered office from one city to another. One city, town, or village to another city, town, or village. This is category number 2. But do you think ROC will also change? If we are changing our registered office from Bangalore to Mysore, ROC will change kya? ROC will be same. Are we clear with this? ROC will be same. If I am changing my registered office from Bangalore to Tumkur, it is also here in Karnataka. Yes, Chikmagalur. Will the registered office change? No, it is also in Karnataka. Are you understanding? It is also in Karnataka. So ROC will not change. But remember, there are two states where there are more than two ROC. Which are those? Maharashtra and Tamil Nadu. In Maharashtra, there are two ROC, one in Mumbai, another in Pune. And in Tamil Nadu, there are two ROC, Chennai and in Coimbatore. Now listen, let's talk about Maharashtra. In Maharashtra, I am changing my registered office from one city to another. Mumbai is one city within the same state. Pune is one city within the same state. I am changing my registered office from Mumbai to Pune. Mumbai to Pune. So is it within the same? Is it within the same state? Within the same state only, from one city to another. But don't you think ROC is changing? ROC is changing now. Same from see, whole Chennai mein na, half of Chennai comes under this. Sorry, in whole Tamil Nadu na, half of Tamil Nadu comes under Chennai's ROC and half of Tamil Nadu come under Coimbatore ROC. So if you're changing your register office from one city to another in the same state, Tamil Nadu only, in the same state, Tamil Nadu only, but ROC is changing from Chennai to Coimbatore or Coimbatore to Chennai, then it will come under category 3. It will come under category 3. So category 2 and category 3 are same. Shifting your registered office from one city, town, or village to another city, town, or village within the same state, but in category 2, your ROC is not changing. That means it is in all other states except for Maharashtra and Tamil Nadu. But in category 3, it will come where your ROC is also changing, but it can happen only in two states, Maharashtra and Tamil Nadu. Are we clear with this? Yes, everyone? This is your case number 3, where the state is not changing, only a city is changing within the same state. Within the same state. City is changing Bangalore to Mysore, but within the same state. Are we clear with this? Now let's say, if in Maharashtra only you are changing your registered office from one city to another, but ROC is same Bombay only. ROC is not changing. Then you will follow case number 2, if ROC is not changing. Are we clear with this? But if ROC is changing, then you will follow case number 3. This case number 3 is possible only in case of Maharashtra and Tamil Nadu, not in any other case. And the fourth is the last case, which is shifting your registered office from one state to another, which is pretty obvious, pretty common, understandable. Last case is your one state to another. And of course, you cannot shift your registered office outside India. It should be within India. The registered office should be within India. You cannot shift it to outside India. Okay. So if now the last category is, let's say we want to shift our registered office from Bangalore to Bombay, Bangalore to Mumbai. Are you understanding? In that case, our state is changing from Karnataka to Maharashtra. And this is a very big matter, because state government ka revenue also goes. You pay SGST also. State ko also GST you pay when you work in a particular state. So when a company moves from one state to another, now it is the loss of revenue of that state government. So let's say if any company will move from Mumbai to Gurgaon, if any company will move from Mumbai to Gurgaon, so it will be the loss of revenue of Maharashtra state government, because company pay a lot of state taxes also. Are you understanding? So that's why changing your state is a big matter, and it's a very lengthy procedure. Many companies don't want to change their state because of the compliance. The procedure is very complicated if you want to change your registered office from one state to another. But if let's say you want to change your registered office within the same city, the procedure is very simple. It's not complicated. Because see, many times it happens that you are changing your registered office. You are in a corporate building. Yeah, you are in a corporate building. Let's say Electronic City. A lot of corporate offices are there. So your office is in first floor. Now your registered office is shifting from first floor to 10th floor. First floor to 10th floor. Now don't you think it will come under which category? First category now. Is it changing registered office? Yes. Floor is changing now. Every floor is of different companies now. That whole Electronic City is not yours. You have a particular office in a particular floor. Are you understanding? So even if your room number, office number, or your floor is changing, then also it is your change in registered office. But it will come under first category within the same city, town, or village. So do you think we should think, apply your common sense and tell, if we are changing our registered office from, let's say, building number A ka first floor ka office number 1 to third floor office number 10. Let's take an example. We are shifting our registered office from first floor to third floor office number 20. Are you understanding? Same building, same city, Bangalore only. We are not shifting outside Bangalore, within the same city, Bangalore only. For this small matter, for shifting your registered office from, let's say, first floor to 10th floor, will you call general meeting to all this tamasha? You will call general meeting and take approval of shareholders. Shareholders will be like, come here, come here, come. What nice, chada, कान के नीचे. Shareholders will be like, why you are wasting our time, efforts, money for this small matter? So law says that if you want to shift your registered office within the same city, within the same town or same village, it's a very chikkadu matter. It does not require shareholders' attention. Are you understanding? So this can be done only with the board approval. Only by passing board resolution, they can shift the registered office within the same city, town or village. Do we need shareholders' approval? No. We don't need shareholders' approval. We can do that. Who can decide? Board of directors can decide that by passing board resolution. Are we clear with this? But when we talk about shifting city, we are shifting cities. City is changing. We are shifting our registered office from Bangalore to Mysore. In that particular case, we need shareholders approval by way of special resolution. Are we clear with this? And of course, if in second category we are needing special resolution, in third category also we will need special resolution. Yeah. Of course, yes. In fourth category also we will need special resolution. Of course, yes. State is changing. The whole state is changing. So we will need special resolution approval. So basically, guys, whenever you want to shift your registered office, we need the approval of shareholders by way of special resolution. But only in one category we don't need special resolution. If you are shifting your registered office within the same city, town or village, then only you don't need to pass special resolution. But in all the other cases, in all three categories, you have to take the approval of shareholders by way of special resolution if you want to alter or shift your registered office. Is it understandable? Do I need to repeat this? No? Okay. Now come here, guys. Please tell me, if we are changing our registered office within same city, town or village, in Bangalore only, from Jayanagar to JP Nagar, do we need to alter the MOA? Do we need to alter the MOA? Are you sure? Pakka, you are correct. We don't need to change the MOA. Next, case number 2. We are shifting our registered office from one city to another, one city, town, or village to another, Bangalore to Mysore. Do we need to change the MOA? Alter the MOA? No. Okay. Third case. We are shifting our registered office from one city to another, but ROC is changing. For example, in Maharashtra and Tamil Nadu, we are shifting our registered office from Mumbai to Pune. It is from one city to another within the same state, but ROC is changing from Mumbai to Pune. Do we need to alter the MOA? Huh. Just the name of the state is mentioned in MOA. Do we need to alter the MOA? Yes or no? No? Are you sure? Anyone want to say yes? Yes? You are saying we have to alter the MOA? One? Anyone else? Two, three, four, five, six, seven, eight, seven. Seven people. You are saying that we have to alter the MOA. Guys, what do we mention in MOA? Only the name of state. Do we have to change the name of the state? Then why will we alter the MOA? We don't have to mention the ROC name now. We don't have to mention ROC's name in MOA. Remember Infosys ka MOA I showed you. What was mentioned there? State name only, na Karnataka. So we only have to mention state name. That is why in case number 3, you don't have to alter the MOA. Because state is same na. Guys, Mumbai to Pune you are shifting. State is Maharashtra only na. ROC is changing, but state is changing. No. So you don't have to alter the MOA, because in MOA you only mention the name of the state. Are we clear with this? In the fourth case, do we have to alter the MOA? Of course, yes. So this process is very khatarnak. Khatarnak means dangerous. Dangerous. Don't keep your hand in your heart and say all is well, all is well, all is well when we will do this process. This process is very dangerous when you want to shift your registered office from one state to another. Very lengthy and very dangerous procedure. You want to see? See, this is your procedure of case number 1. This is your procedure of case number 2. And this is your procedure of case number 3. And this is your procedure of case number 4. So it's like very dangerous. So we'll do this one by one very quickly. Come here, guys. Case number 1. I have already sent this PDF in the Telegram group, so you can write it down. This PDF, you can write it down after going home in your notebook. If apart from this PDF, if I will give any other example or any other explanation I will give, which is not there in the PDF, which is not there in the material, that you can write in rough or in sticky notes or in the material wherever you find this place. Are you understanding? What is there in the PDF? This you can write at home. What is there in this PDF? This you can write at home, because I've shared the PDF in the Telegram. Apart from the PDF, if I will give any new example, any new explanation, then that you write it down along with the class in your material only. In your material only, you can put sticky notes and you can write them. Understood? Okay. Case number 1. If you're shifting your registered office within same city, town or village in which registered office is situated. Okay. For example, Jayanagar to Koramangala, let's say. Okay, everyone. Now, in that particular case, you don't need to take shareholders approval, because city is not changing now. So it doesn't require shareholders attention. These approval can be taken by board of directors only. It is not that serious matter that we need to call shareholders meeting and we need to take shareholders approval. It is not that serious. So only in this first case, which approval do we need? Guys, we only need the approval of board of directors by way of board resolution. The approval of board of directors is known as board resolution. Okay. Now, don't you think you have to inform to someone? You have to inform ROC, possessive boyfriend. You have to inform to ROC. ROC. Our address is changed. Don't you think you have to get your new address verified by ROC? Remember, Section 12 may be studied that whenever we shift our registered office or we alter our registered office, every time we have to get our new address verified with RC. And we have studied the form number also. What is the form number for verification of registered office? INC 2222. Remember, INC 22 is for verification of registered office. This we have to file during incorporation also. After a new company gets incorporated, you should have a registered office within 30 days. And within 30 days, you have to verify your registered office with ROC by filing a form number INC 22. So when first time you set up registered office, that time also you have to file INC 22 for verification. And when you change it subsequently, that time also you have to file INC 22 to ROC for verification of the address. Are we clear with this? So since your address is changed, so you have to file INC 22 within 30 days to ROC for verification for verification of your registered office. Are we clear with this? For your verification of registered office. Clear? Case number 1 is simple. So if we will make this chart you don't have to make an examination. This is just for your revision. This is just for your understanding and revision. In case number 1, do you have to pass board resolution? Yes. Do you have to pass special resolution? No. Guys, if we have not passed special resolution, do we need to file MGT 14? No. Why? Because MGT 14 is filed to ROC whenever we have to pass special resolution. Now, do we have to take RD approval, central government approval? No. We don't have to take central government approval here. And guys, there is one more form in this address change. Whenever we have to take central government approval, now we have to file one more form to ROC, which is INC 23, which is for copy of order of central government. So do we have to file INC 23 here? No. Why? Because we do need approval of central government. Next, do we need to do alteration of memorandum? No. But we need to file one form to ROC, which is INC 22 within 30 days. Do we have to file this? Yes. This we have to file because we have to inform ROC about the address change, even if address is getting changed from first floor only room number 1 to room number 10. If our registered office address is changing from first floor room number 1 to room number 10, then also we have to file INC 22 to ROC within 30 days. So whenever there is an address change, there is a change in registered office, we have to file INC 22 within 30 days to ROC. Are we clear with this? This is case number 1. In case number 2, if you are shifting your registered office outside the local limit of city, town or village. What do you mean by outside the local limit of city, town or village? It means from one city, town, village to another city, town, village. Bangalore to Mysore. Example. You can write here example Bangalore to Mysore. Okay. Now, in this case, guys, do you need shareholders approval? Yes. Do you need shareholders approval? Yes. Do you need government approval? No. ROC is not changing now. Please understand. ROC is not changing. So you don't need government approval here. Only shareholders approval is enough. And whenever you need shareholders approval, do you need to call board meeting also, and do you need to pass BR also? Yes, because for calling general meeting, you need to pass board resolution also. So if you want to shift your registered office from one city, town, village to another city, town or village, but ROC is not changing, in that case you need to pass board resolution, and then you need to pass special resolution, and then Fevicol. Whenever there's a special resolution, you have to file FGT 14 within 30 days to ROC, and you have to verify your new address with ROC by filing INC 22 within 30 days to ROC. So here you have to file 2 forms to ROC. Same thing is written in this table also, guys, just for comparison. If it is case number 2, ROC is not changing, but you are shifting registered office from one city to another. That's a Bangalore to Mysore. Do you need to pass board resolution? Yes. Do you need to pass special resolution? Yes. And since SR, so you need to file MGT 14 within 30 days to ROC. Do you need to take central government's approval? No. Do you need to file INC 23? No, because INC 23 you file if you have to take central government's approval. Do you need to do alteration of MOA? No. But do you need to verify your new address? Yes. You need to verify your new address by filing INC 22 within 30 days. Right? Easy peasy. Case number 2, 1 and 2 are so super easy. Now comes a plateau. These two are plain. This is a plateau. Case 3 is a plateau, and case 4 is a mountain. Case 4 is a mountain. We will complete this. We will try to complete this before break. So now come here. Case number 3. Case number 3. Acha, should we read this first from the material and then continue? Come to the notes here only. Case number 3. Process of obtaining RD approval in case number 3, that is, you're shifting your ROC within the state from jurisdiction of one ROC to jurisdiction of another ROC. Case number 3 talks about if you are changing your registered office from one city, town, or village to another city, town, or village within the same state, but ROC is changing. This can happen only in case of Maharashtra and Tamil Nadu. For example, your ROC is changing from Mumbai to Pune. It is within the same state, Maharashtra, but guys, RC is changing, and that is why we need RD ka approval. Whose approval do we need? RD. Because RC is changing now, guys, it is pretty logical. Earlier we were under Mumbai RC, now we will be under Pune ROC. So we don't need ROC approval. Because which ROC will approval take now? Mumbai or Pune. So we need approval of one level above authority, which is RD. In that case, we need the approval of RD. So, if you are changing your registered office from one city town village to another city town or village within the same state where ROC is changing, jurisdiction of ROC is changing, in that case, you will be needing the approval of regional director. Do you need shareholders approval also? Yes, of course. You need shareholders approval also. So, if you see this chart, in case number 3, you need to pass BR? Yes. You need to pass SR? Yes. Whenever there is SR, Fevicol, MGT 14 within 30 days, you have to file? Yes. Do you need RD approval? Yes. And since do you need RD approval, do you need to file INC 23 also? Yes. But do you have to alter the memorandum? No, because date is not changing. Do you need to verify your address by filing INC 22? Yes. So you know what? In this 3 forms will come. You have to file MGT 14 also to ROC. You have to file INC 23 also to ROC, and you have to file INC 22 also to ROC. Now, very quickly, I'll do this procedure. Very carefully, everyone to the board. Everyone to the board. The process, step-by-step process of altering. First, what you have to do, first of all, you have to take regional director ki approval. The first thing that you have to take is regional director ki approval. And how you will take regional director ki approval? You will make an application to RD. How you will make? In the form number INC 23. Guys, a little correction. INC 23 you don't file to ROC. Sorry. INC 23 you don't file to ROC. INC 23 is a form for making application to regional director. In which the form for application. Application form is there. Application form is there in INC 23. You have to fill that form to apply to RD. To apply to RD for getting the approval of the RD. So the step one is you have to make application in the form INC 23 to RD. So imagine there's a company is filling this form and company is submitting this form to RD. Now, don't you think along with this form we have to attach some proof of address change, some proof that this new address belongs to us, why we are changing the name. So there are some documents which you have to attach along with this form INC 23. What are those documents? Copy of board resolution, copy of special resolution as a proof. Have you taken shareholders approval? Have you taken board's approval? Show us a Xerox copy. Show us a Xerox copy of board resolution and Xerox copy of special resolution so that ROC will check. ROC will check whether you have taken shareholders approval or not, whether you have taken board's approval or not. So you have to attach a PDF of copy of board resolution and a copy of special resolution along with this form INC 23. In every form now there is an option to attach PDF. So you can attach all these documents. You can attach all these documents to this form, and that is why these are known as attachments. Are you clear with this? What all attachments you have to add along the form INC 23? Copy of BR, copy of SR. Declaration from one KMP or two director. Either one KMP. KMP means key managerial personnel. Basically CEO, CFO, CS, all these people come under key managerial personnel. KMP or two director will give a declaration. We have to give a declaration that there is no default in workman dues. Guys, please understand. Two people are mostly affected by your address change. Don't you think if a company's office is here in Bangalore, then if we are changing our registered office from Bangalore to Mysore, two people will be affected. First, employees. Those who are in Bangalore, local people of Bangalore, and they're working here, don't you think it will be difficult for them to shift to another city, because they are doing job in that company, they're doing employment. So first, people who will be affected by this is employees. Second, people who will be affected by this is creditors. Let's say you have taken any loan or any credit, something on credit from someone in Bangalore. If that person is in Bangalore, that person can easily approach you and ask for the payment. But if company only shifted to another city, then creditors will be like, now how can we recover our money? Now it will be difficult for us to approach you. We have to go travel to the different city. So the two people who are mostly affected by this is creditors and employees. So here government want to make sure that you are not shifting registered office to escape from any payment of creditor or to escape from any payment of employee. So government want to make sure that the interest of employees and interest of creditors of that company are not affected if that company is shifting its registered office from one city to another. Are you understanding? So that is why if our company, let's say Yeshas Academy, we are changing our registered office from one city to another, where ROC is changing. Sorry, let's say Mumbai to Pune. Mumbai to Pune, this is case number 3 now. Mumbai to Pune, we are shifting. So ROC is changing. So ROC will allow this change. RD will allow, regional director will allow this change only if we will make a declaration. KMP and director will make a declaration that, sir, we promise we have paid all the employees' salaries and employees' dues. We have no pending government dues. First thing, we have to give this declaration, pinky promise. Secondly, we have to give a declaration promise if we have any creditor, either we have paid all the money to the creditor or we have taken their consent. We have taken consent of our creditors. Our creditors have no problem with us shifting from Bombay to Pune. Are we clear with this? Because these two people are affected because of the change of address of the company. So that is why you have to take a declaration from KMP or to director. What they will declare? They will declare that we have no default in the payment of workmen dues first. Secondly, we have obtained the consent of the creditor or has made provision for their payment. Has made provision for their payment means we have made arrangements for the payment of their money already. Then only RT will allow the change. We have to attach this declaration in PDF form into this form number INC 23. Next, we have to give an acknowledgement. Sorry, we have to give a copy of intimation to Chief Secretary of the state that employees' interest is not adversely affected. Guys, every state ka there is a chief secretary. There is a government authority called Chief Secretary of State. So we have to give this intimation to Chief Secretary of the state that, sir, we promise that employees' interest is not negatively affected, not adversely affected by our shifting from Bombay to Pune. We have to give an intimation to the Chief Secretary of the state that employees' interest is not adversely affected, and a copy of that intimation, Xerox copy of that intimation you have to attach along the form INC 23. Are we clear with this? So till now, everyone, what is the process of shifting your registered office from one city to another where ROC is changing? Example, Bombay to Pune and this Chennai to Bangalore. So company has to first make an application in the form number INC 23 to RD to first of all take the approval of regional director. Along with this form, you have to attach all these documents. Now, RD will pass order either approving or rejecting within 15 days. RD has 15 days. ROC will check your application. If ROC feels that none of the employees and creditors are impacted, then RD will approve the shifting of registered office. If ROC feels that interest of any employee or any creditor is adversely affected, then ROC will reject your shifting. ROC will not allow your shifting of registered office from one city to another where ROC is changing. Are we clear with this? Now, if RD has approved, now don't you think we need to take approval of shareholders also, guys? So wait. The first thing that we did is passing SR. The first thing that you'll do is call board meeting, pass board resolution, call general meeting, pass special resolution. First, you will take shareholders approval, board's approval, then shareholders approval, then you will apply to RD and then you will take RD's approval. Are we clear with this, everyone? First, you will take board approval, then you will pass BR, then you will pass SR, and then you will apply to RD and you will take RD approval. All the approvals taken, board approval also taken, shareholders approval also taken, and government approval also taken. Now it's time to file all the forms to ROC. You have to file 2 forms to ROC because SR is passed. So you have to file MGT 40 within 30 days, and because registered office is changing, so you have to file the verification form, which is INC 22. Okay, so now after you will get an order, first of all, whenever you get order from, let's say, central government or RD or NCLT, you have to send a Xerox copy of that order to ROC. Always, everything you have to inform to ROC, literally everything you have to inform to ROC. For example, if you are getting order from central government, we got an order from regional director. So this also we have to inform to ROC. ROC, we got order from regional director. So first thing, if you get order from regional director, you have to file a copy of that order of regional director to ROC in the form number INC 28 within 30 days of the order. So there is one more form, INC 28. Guys, I'll tell you what is INC 28. Whenever you get any order from any authority such as central government, RD or NCLT, then a copy of that order you have to file to ROC in the form number INC 28. Now we have to file two more forms, which is, which I have not mentioned here. We have to also file plus MGT 14 within 30 days, and we also have to file INC 22 within 30 days of passing of special resolution for verification of the register office. Now, these three forms we have to file to ROC, INC 28 and MGT 14 and INC 22. It is not there. I have already shared the PDF now, so later you can include it in your PDF. And lastly, don't you think ROC will register the new address? So now ROC will certify your new address within 13 days and will issue a new certificate. Will issue a new certificate evidencing the change of ROC, which will evidence that your ROC is changed, and this will be from that date only your name change, sorry, registered office change will be effective. Your registered office change will not be effective from the date you pass SR or from the date you take RD approval. No, your registered office change will be effective when ROC will register the same and when ROC will certify you. Yes, name change registered by ROC, then your name change will be effective. Sorry, registered office change will be effective. That's all about the process of shifting of registered office from one city, town or village to another city, town or village. One city, town or village to another city, town or village within the same state where the jurisdiction of ROC is changed. Clear? Let's read it from the book. Come to the material. Guys, case number 1 is same to same given in the notes. You can read it on your own. Okay, case number 2 is same to same we have done from the notes. Literally, nothing is extra. Same to same we have done from the notes. Copy paste. Language is also very simple. So case 1 and case 2 you read on your own. Also in case 1 you can write here special resolution है तो file MGT 14, like file MGT 14 within 30 days. File MGT 14 within 30 days to ROC. File MGT 14 within 30 days to ROC. And one more thing, you have to intimate to ROC for verification of registered office by filing a form INC 22 within 30 days. You don't need to do both of these points. What you can do, you can cut this first para and simply you can do this. After changed, you can do from here. Outside the local limit of city, town or village by virtue of special resolution passed by the company. That's it. This postal ballot wala part ignore. We will do this in general meeting chapter. So basically, Case number 2 also, if we will read, if we want to change your registered office from one city, town or village to another, then you need to pass special resolution passed by the company, and then you can change your registered office from one city, town or village to another. That means outside the local limit of city, town or village by virtue of special resolution. Same thing is given here. That's it. Now come to case number 3. If you want to change your registered office within the same state from jurisdiction of one ROC to jurisdiction of another ROC, except in case of, sorry, that is only in the case of Maharashtra and Tamil Nadu. Then it is given in section 12. You can write here section 12. It is given in section 12. Case 2 is also given in section 12, and case 1 is also given in section 12. Case 1, case 2, case 3, all 3 cases are given in section 12. So now come here. No company shall change the registered office from one jurisdiction of ROC to another within the same state unless it is confirmed by RD. So it tells you that in this case you need permission of RD. Next, this and this cut. These 2 paragraphs you can cut. And third, ROC will record the changes. Of course, ROC will record the changes. ROC of the state where the registered office was previously situated will transfer all the documents to the new ROC. For example, if your company is shifting from Bombay ROC to Pune ROC, then Bombay ROC will transfer all the documents of that company to Pune ROC. Now come to rule. Now in section only this much is mentioned. In section 12, only this much is mentioned that you need RD approval by following the process as may be prescribed. Now this whole lengthy procedure that we did now, it is not given in section 13, 12. It is not given in section 12. It is given in rule. It is given in rule. Now all the detailed procedure that we just did is given in rule 28 of the company's incorporation rule. All this detailed procedure that we did is given in rule 28 of the company's incorporation rules. Now we are reading the rules. In rules, detailed procedure of shifting your registered office is given in case of case 3. How you will shift registered office? The application seeking the confirmation from the RD for shifting your registered office within the same state should be in the form number INC 23 along with the fees. So they are saying you have to make application to RD by filing a form INC 23 along with following documents. What documents you have to attach along with INC 23? Copy of PR, copy of SR, a declaration given by KMP or to director that company has not defaulted in the payment of workmen dues and the company has taken the consent of creditors or had made necessary provision for their payment. Same thing we have done. Next, you have to also give an copy of intimation to Chief Secretary of the State, copy of intimation to Chief Secretary of the State that employee's interest is not adversely affected. One more attachment is there not mentioned in the notes. Declaration not to seek any change in the jurisdiction of the court where cases for prosecutions are pending. Prosecution means criminal case. Prosecution means criminal case. So if any criminal case is pending against the company, if any criminal case against the company is going on, then you have to give a declaration that you will not seek the change of jurisdiction of court. Because if you will change your registered office from Mumbai to Pune, court ka jurisdiction will also change now. Earlier you will come under the Pune ka Mumbai ka court, now you will come under Pune ka court. So you have to make a declaration that we will not seek the change in jurisdiction of the court if there is any pending litigation or prosecution is going on. All this document you have to attach along with the form INC 23. Now RD will examine the application. RD will do what? Examine means check the application. After examining the application, if RD may either approve the application or may reject the application. So RD will by order either approve or reject the application within 15 days of the date of receipt of application. Within 15 days he will approve or reject the application. Now the copy of order of RD will be filed in the number INC 28 to ROC within 30 days of the receipt of copy. From 30 days, within 30 days from the receipt of copy, we have to file a copy of order of RD to ROC within 30 days in the form number INC 28. Do you have to file MGT 14 and INC 22 also? Yes. So it is not given here, but you can you can write here, you also have to file MGT 14 within 30 days of SR. And MGT 14 you have to file within 30 days of SR. But INC 28 and INC 22 you have to file within 30 days from the date of order of RD. What I am saying is MGT 14 you have to file within 30 days of SR to ROC. to ROC. But INC 28 and INC 22, you have to file to ROC within 30 days from the date of order of RD. Within 30 days from the date of order of RD. Within 30 days from the date of order of RD. Are we clear with this? Shall we do case number 4 also? No? Why? I wanted to complete this before break. Okay, we'll have a break. Are you hungry? Yes? No? How many fishing ma'am complete this fourth case and then have a break? One. Only one student. That's why Girish is my favorite student. ठीक है, fine. You had your breakfast and cake. You are hungry. Bread and jam. So you don't have anything before the class. Your empty stomach. ठीक है. We'll have a break till 11, but we will start at 11 now because too many topics are left for today. So we will have a break till 11 and we will continue case number 4. So if you come early now after your thingy, you can revise case number 3, or if you want case number 2, case number 3, you can keep revising like if you come early, if you're done with your thingy. So we'll have a break till 11 and we will continue our case number 4. Okay. Have you understood all the topics till now? Easy? Shifting of registered office? Okay. See you after the break. Cindy, Mari, Patti. Online students also see you after the break.
Dear online students, let me know in the chat box if I'm properly visible and audible to all of you.
Yes. Okay. So everyone, please come to case number 4. Case number 4, that is shifting of registered office from one state to another. Shifting of registered office from one state to another. In your material, it is in page number 6666. And first we will do it from the notes and then we will do it from the material. So so guys, we discussed the 4 case that if you want to shift registered office within same city, town or village, let's say from Jayanagar to JP Nagar, you just need board resolution approval. You don't need any shareholders approval also. If you're changing from one city, town or village to another city, town or village, which we say outside the city, town or village, but no change in ROC, no change in ROC, then you need board approval also and SR approval also. Government approval you don't need. But if you're changing from one city, town or village to another city, town or village where ROC is also changing, then you need board approval also, shareholders approval also, and you need RD approval also. And in the last case where you are changing from one state to another state, then also you need board approval, you need shareholders approval also, and you need central government approval also, power delegated to RD. Okay, original power is with central government and then it is delegated to RD. So you know that in this case, if you're changing our registered office from, let's say, Chhattisgarh, from Bangalore to Chhattisgarh, Bangalore to Chhattisgarh, state is changing. Yes. Do we need board approval? Yes. Do we need SR? 75% shareholders approval, yes. And also we need permission from government. Without permission from RD, you cannot shift your registered office from one state to another. And you know what, before giving approval, a regional director will make sure that it is not adversely affecting, the shift is not adversely affecting the employees and the creditors. Government will make sure that all the employees are paid, all the creditors are paid, then only government will allow you to shift your registered office from one state to another. So before shifting this, you have to make sure that none of the employees and the creditors interest are adversely affected because of this shift in registered office from one state to another. So now, guys, if you know, within the same state, like in case number 1, 2, 3, is it causing alteration of memorandum? No. So that is why it is not given in section 3, it is given in section 12. These three cases, case 1, case 2, and case 3, are given in section 12 because section 12 talks about the registered office of the company. Section 12 talks about the registered office. So there only this shift of registered office in these three cases are given. Only the fourth case involve alteration of memorandum. That is why it is given in section 13, because section 13 talks about alteration of MOA. Section 13 talks about alteration of MOA, and only in the last case there is alteration of MOA, and that is why only this last case, case number 4, is given in section number 13. Rest all three cases that we did before are given in section number 12. Now there is one new concept is in case number 4, because if a company will shift its registered office from one state to another state, there can be many people who are affected by it. There can be lots of employees of that company, lots of creditors of that company, and other public. And if it is a listed company, then the huge public might get affected by it. If it is a listed company, if it's a big listed company, and you're changing your state from, let's say, Karnataka to Maharashtra, then many people might object the same. If your employee, your interest is adversely affected, even government can, state government can also object. Karnataka government can object, no, it will be loss of our revenue. So that is why there is a concept of publication. There is a concept of newspaper publication. There is a concept of newspaper publication, which means government asks you, RD asks you, when you go to RD now for permission, ki RD, I want to shift my registered office from one state to another. RD asks you, first go publish this in the website, in the newspaper and the website. In one English newspaper, one Hindi newspaper, one local newspaper. Publish it so that everyone will get to know, assuming everyone reads newspaper. Are you understanding? So that everyone will get to know about it, and if anyone has any objection, then they can send their objection to the government. So there is this concept of newspaper publication to inform everyone, I call it government hindora. Government hindora pitna. Government hindora means tell everyone what is happening, tell everyone. Okay, मामा मामा गांव वालों को बता दो, बाहुबली आ गया है. Okay, so basically, if you will come here to the process, now we'll be doing what is the step-by-step process if you want to alter your registered office from one state to another. Then of course, let's say you are a company and you want to alter your registered office from one state to another, then the first thing that you have to do is call a board meeting and pass a board resolution, and then issue the notice of the general meeting, and then hold a general meeting and pass a special resolution. So the first thing that you have to do is take board's approval and take shareholders approval, board's approval by way of board resolution and shareholders approval by way of special resolution. Now Fevicol, MGT 14, whenever you have to pass SR, within 30 days of passing SR, you have to file MGT 14 to ROC. Now, don't you think you have to take government approval, RD approval? But before RD approval, you have to do government hindora. Government hindora means you have to inform everyone. Gaon walo, suno, listen. We are going to change our registered office from Karnataka, Bangalore to Mumbai. Anyone has any objection? Anyone has any objection? Anyone has any objection? If anyone has any objection, you can submit your objection to the company or to the government. RD. Are you understanding, guys? So now within 30 days before application, within 30 days before application means whenever you are going to apply to RD, before 30 days before that you have to make newspaper publication in the form. Even the format of that newspaper, what you will publish, you will see in newspapers now there is one page which is specifically business section. In newspaper there is one page now which is specifically business section, only the business news, companies news are there. In one dedicated page is there in the newspapers for the business section. Are you understanding? So there you have to publish that notice that we are going to, this company is planning, is going to shift registered office from Bangalore to Bombay. And the format, what you will write in that advertisement, newspaper advertisement, what you will write in what format, that format is prescribed. That format is prescribed, you just have to do fill in the blanks. The format of newspaper publication is prescribed in the form number INC 26. Now where you have to publish, you have to do advertisement, meaning you have to inform about this in one vernacular newspaper. Vernacular means local language newspaper. So if your company is from here, Bangalore, then you have to publish in one Kannada newspaper and one English newspaper. For example, Times of India and all this. Okay, one English newspaper, which is having circulation in the whole state. In the whole state means you have to publish in such a newspaper which is being circulated in all of the Karnataka. Let's say there are some newspaper which are only for city specific. Let's say there are some newspaper only for Bangalore. They are circulated only in Bangalore, not in other states of Karnataka. There are some newspaper which are circulated all over the Karnataka. So you have to publish in such a newspaper which is circulated all over the state. All over the state means all over the Karnataka. In vernacular language newspaper, English language newspaper which is circulated all over the state. Are we clear with this? Newspaper which is distributed in all the state of Karnataka. And there are some people who are VIP. There are some people who are VIP, means important people. They are like, we will not come if you will just send us PDF invitation. You have to specifically call us and ask us to come, then only we'll come to your wedding, like your Fufaji. If simply you will send them invitation card, they will not come to your wedding. You have to give them special invitation. Call them, Fufaji, come to the wedding. To call them, and you have to request him to come, then he will come to the wedding. So there are some people who are VIP. To them, newspaper advertisement is not sufficient. We have to individually inform them. Separately, we have to inform them about this change. Why? Because their interest is adversely affected. Their interest might get affected by this change in a state. Who are those people? Two people, creditors. Don't you think debenture holders are also the creditors? Debenture is also debenture holders are also creditors. So you have to specifically send notice of this change in state to creditors, debenture holders, and some government bodies like ROC, SEBI only if the company is listed. If company is not listed, then no need to send it to SEBI. If the company is listed, then you have to send it to SEBI also. And any other regulatory body. Regulatory body means government body. Any other government body if applicable. For example, if your company is in if your company is in non-banking financial activity, then you have to send notice to RBI also. Are we clear with this? So any other regulatory body depending upon the applicability. So you have to send notices to all these people individually. Okay. Now when you now newspaper publication is done, if anyone will have any objection, they will submit their objection to the company. Now can we apply to RD for taking RD's approval? Yes. Now you can apply to central government power delegated to RD. In which form? Same INC 23. And there are some documents which you have to attach with INC 23, and most of the documents are same which we did in case 3. What documents? Copy of BR, copy of SR, same. Declaration by CS plus 2 director, one of whom shall be MD. Wait, this is a different point. This point is same. Copy of acknowledgement of a service of copy to the chief secretary of the state that none of the employees interest is adversely affected. This is same. Yes. Some extra documents you have to attach here in case number 4. For example, minutes of general meeting. Now, what do you mean by minutes? Summary. How do you know? CSET, BCR. Okay. You have done CA foundation. Yes, 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 yes. Yes. So, guys, do you know in parliament, whenever parliament is in session, whatever discussion is done in the parliament, there is one person who's constantly typing. what is being discussed in the parliament, to take a note down of the meeting, what people are discussing, what people are saying, everything is noted down. Same is the case with the minutes. Let's say we are doing the general meeting. We are doing the general meeting and we passed three resolutions, two ordinary resolution, one special resolution. So all the decisions that we have taken, all the discussions that we have done is noted down in a document. In this meeting what happened, this was discussed, this was discussed, and this resolution was passed. So everything that is being discussed in the meeting, because meeting mein to we will do oral discussion na, it is not in writing as of now. Meeting may we will do oral discussion, we will do oral voting. Are you understanding? So to make it official, whatever is being discussed in the meeting, we write it in a piece of paper, and that document is known as minutes of the meeting. Minutes of the meeting means recordings, written record of the meeting. Are we clear with this? So don't you think if you have to pass special resolution, you have to call meeting for that? Yes or no? If you have to pass special resolution, then you have to call general meeting for that. Yes, guys. And whatever is being discussed in the general meeting, we will prepare minutes of that general meeting. So that minutes of general meeting also you have to attach along with the form INC 23. Along with the form INC 23. Okay, everyone? Yes. Next is your copy of MOA AOA with proposed alteration. Why, guys? Because here it will involve alteration of MOA and AOA. In article also we write the name of the state. So here in this case we have to alter our MOA also, and we have to alter our AOA also, which was not there in the previous three cases. So we have to attach a copy, Xerox copy of our MOA and AOA along with the alteration, means altered copy of new copy of MOA AOA we have to attach along with the form INC 23. Are we clear with this? So copy of MOA along with proposed alteration. Next, list of creditors and debenture holders. Let's say we have taken loan from some XYZ people and we have issued debentures to some ABC people. So we have to give complete list of all our creditors and debenture holders along with how much we owe to them. Meaning, let's say we have taken a loan of 10 lakh from SDFC Bank, 10 crore from SBI Bank. So we have to give a list of creditors. SDFC Bank along with amount, how much amount we have taken loan from them, how much we are in the debt towards them. So SDFC Bank 10 lakh, SBI Bank 10 crore. So we have to give a complete list of creditors and debenture holders. How many creditors are there from whom we have taken borrowings? Are we clear with this? Along with the amount. Now we have to give a declaration. Declaration means simply we will declare pinky promise. It's like in exam, don't write pinky promise, write declaration. This is just my personal way to explain you. Okay. So declaration we have to give. Who will give declaration? One CS. If there is a CS in a company, compulsory, plus two director. There will be three signature in this declaration. Three signs should be there. One CS ka sign is needed. One CS signature, CS of that company will sign, and two director will sign. Two director will sign. Out of those two director, one director should be managing director. Who is managing director? As of now, understand, managing director has the substantial powers of the company. Managing director. We will study about this in very detail in part B KMP chapter. Okay, so who will sign this declaration? One CS and two director, three signatures. Out of these two director, one should be managing director. Okay, now what we will declare? We will do pinky promise. We will declare three things. First thing, sir, we promise all the list of creditors and debenture holders that we have provided is correct. We are not, giving any fake details. All the list of creditors and debenture holders that we have provided is correct. We are declaring you. Sign karke. This is correct. Second, all the value of debt are proper estimate. Let's say if we are saying you value of debt, we owe SDFC Bank 2 crores. We have taken a loan of SDFC from SDFC Bank 2 crore. So that value of debt is proper estimate. It's not a false number. That is a proper estimate as per us. Means that number is a correct number. That value of debt that we are providing. Third, no employee will be retrenched. Retrenched means just because we are shifting from Bangalore to Bombay, we will not remove any employee. If they are willing to shift to Bombay, they will be given job in Bombay also. We will not retrench them. We will not remove them from the company. We will give them job in Bombay office also. Are you understanding? We have to give a pinky promise. Means we have to give a declaration. Who will give declaration? Declaration has to be given by one company secretary and two directors, out of which one should be managing director. What we will declare? They will declare that The list of creditors and debenture holders that we have provided is true and correct to the best of our knowledge. And the value of debt that we have provided is also true and correct and proper estimate according to us. Number 3, we will not retrench any employee, which means no employee will be retrenched. This 3 declaration we have to give. Arthaita. Yes. Next, details of objection. Remember we did newspaper publication into newspaper, English and vernacular. Why we did newspaper publication? So that if any particular public has any problem, has any objection, they can inform the company ki I have problem, I have this problem. Are you understanding? That is known as objection by public. Objection by public. So if company has received any objection from public pursuant to the newspaper publication, if we have received any objection from public, then all the copy of those objection we have to submit to RD along with the form number INC 23. Easy to understand? Are you able to understand all the documents that you have to attach along with the form INC 23? Yes. So uh, till now, I will just revise the process from the very starting. Okay, we are doing case number 4, that is shifting of registered office from one state to another, Bangalore to Bombay, Karnataka to Maharashtra. In this particular case, what approvals do you need? You need board approval also, you need shareholders approval by way of special resolution also, and you need central government approval also. So what is the step? First, you have to pass board resolution, call board meeting, pass board resolution, and then call general meeting, and then pass special resolution. Fevicol, whenever there's special resolution, you have to file MGT 14 within 30 days to ROC. Next, guys, there is one extra point in this, because the state is changing now. You have to make newspaper publication, you have to inform all the public of Karnataka about this change in registered office, so that if anyone has any objection, they can submit the objection. So you have to make newspaper publication at least within 30 days before the making application. For example, if you're planning to make application on 31st of January to 2025 to RD, then somewhere between 1st January to 31st January, you have to make newspaper publication. Somewhere between 1st January to 31st January, you have to make newspaper publication. And then by 31st January, you have to apply to RD. Are you understanding? So when you will apply to RD, before that, 30 days before that, 30 days prior, 30 days prior to making application to RD, you can make newspaper publication, and the form is given. Form is INC 26. In which newspaper? One English, one vernacular, which should be circulated in the whole state. You have to give special notice to some people. For example, creditors, debenture holders, ROC, SEBI, regulatory body. Guys, employees ko you don't need to give separate notice. Why? Because if it is a big company, there are thousands of employees. It is not possible to give separate notice to thousands of employees. So employees ko you don't need to give separate notice. Employee, we will assume that they will read from the newspaper only. Are we clear with this? So you need to give special notice to creditors, debenture holders, ROC, SEBI, and any other regulatory body. And thereafter, you need to apply to RD for approval in the form number INC 23. Along with INC 23, some documents you have to attach. For example, board resolution, special resolution, minutes of general meeting, copy of MOA along with alteration of MOA, altered MOA, list of creditors and debenture holder, and then a declaration by a CS and 2 directors, one of whom shall be MD, that first, list of creditor and director is correct. The value of all the debt are true and correct and proper estimate. And third, no employee will be retrenched. Apart from that, we need to give a copy of acknowledgement of that we have sent a copy of service of copy, means we have sent a copy to the chief secretary of the state that no employee's interest is adversely affected. And lastly, we have to send a copy of objection if company receive any objection from any particular public. Are we clear with this? And thereafter, till now, is it easy till now? Easy till now? Now, we have applied to RD. Now, RD will either approve the application or reject the application. What RD will do? RD will either approve or reject. If RD feels that none of the employees and creditors' interests are affected, then RD may approve the shifting of registered office from one state to another. If RD is of the opinion that any employee's interest or creditor's interests are adversely affected, then RD may reject the application of the company for shifting from one state to another. Now, in how much time RD has to reply? So the time limit is different if there are no objection and if there are objection. Guys, first situation, if no objection is received from public, remember we did newspaper publication so that if anyone has any objection, then you can submit your objection. If not a single person has any objection, then RD will also have no objection. Ki, acha, no one has an objection, green flag, go with it. Are you understanding? Guys, if no one has objection, then why would ROC have problem? Why would ROC have problem? Mia bibi razi to kya karega kazi? Like if ROC, if company don't have problem, employees don't have problem, creditors don't have problem, public don't have problem, then why would government have problem? Are you understanding? So if there is no objection, means everyone is happy. Employees are also good, creditors are also good. No one is having no objection with the shifting of registered office from one state to another. Then no need to do the hearing. Hearing means hearing court proceedings of both the parties. No need to do hearing, so time limit is left. In that case, central government will pass the order either approving or rejecting within 15 days of the application. Are we clear with this? However, if objection is received, let's say certain category of employees said we have objection, we can't shift to Maharashtra, our job will be gone, we have objection. Let's say some creditors are saying they will not pay us the money, lot of money they have owed from us. So if anyone is objecting, we have problem, creditors are saying we have problem, employees are saying we have problem, we don't want this company to shift from Bangalore to Bombay, then hearing will be done. Hearing means proper court proceedings. In one side company will be there, and in one side people who have objection will be there, employees and creditors. And RD will do the hearing. Okay, you say what you have to say, okay, you say what you have to say. RD will hear the both the parties, just like in movies you see na court proceedings. In movie you see court proceeding, on one side the person, the complainant is there, on the one side the culprit is there, and judge hear both the parties. Judge hear both the parties, what you have to say, what you have to say, and then judge gives final decision, just like a court proceedings. Are you understanding? So here RD will do the hearing. Hearing means RD will hear both the parties, companies also and public also who has objection. And after hearing both the parties, now RD will take the decision. Now RD will take the decision. Now, depending upon the situation to situation, RD may approve the application or RD may reject the application. But the hearing process will take some time. That is why here the time limit for giving the decision is 60 days. Are we clear with this? So here in this case, ROC will either approve or reject the application after doing the hearing of both the parties, and will give the judgment within 60 days. Are we clear with this? So here what we are studying, guys, everyone, if a company wants to alter its registered office from one state to another, will pass BR, SR, newspaper publication, and then we will apply to RD in the form number INC 23 along with some attachment. If no one has objected, then RD will either approve or reject the application within 15 days. However, if objection is there, then RD will first do the hearing and then will either approve or reject the application within 60 days. Just a time limit difference is there, because if no objection is there, no need to do hearing. So RD can pass judgment in less time, in 15 days. But if there is objection, then hearing has to be done. So it will take a little bit more time now. So that is why in that case, RD can give the judgment within 60 days. Now, company received judgment from RD. Don't you think we have to file the copy of order of RD to ROC? We got order from RD, we have to inform our ROC na. ROC. We got order from RD. In which form? INC 28. So now step number 4, you have to file a copy of order of RD in the form INC 28 along with the copy of altered MOA and AOA to ROC within how many days? Within 30 days of the order of RD. When you will get order from RD, order of RD. Okay, so within 30 days of the order of RD, you have to file a copy of order of RD to ROC in the form number INC 28 along with a copy of altered MOA, because this is case number 4 here. MOA is altering, guys. In MOA, we have to prepare a new MOA. Name of state is changing now from Karnataka to Maharashtra. Guys, are you understanding? MOA will be altered here. AOA will also be altered here. AOA may be also we mention the name of the state. So we have to alter the MOA and the AOA. And don't you think address is changing? So we have to get new address verified with ROC. in the form number INC 22. So again, we have to file INC 22 within 30 days of the order to ROC. Now, which ROC? New ROC or old ROC? If we are shifting from Karnataka to Maharashtra, let's say Bombay, then we will file this INC 28 and INC 22 to Bangalore ROC or to Bombay ROC. Bombay ROC. Are we clear with this? So we will submit this to that ROC of the state where RO is shifted. We have to submit this to ROC of that state where we are shifting. We are shifting to Bombay, so we have to submit this to the ROC of Bombay. Are we clear with this? Now there are some documents that you have to attach along with the verification always. Acha, this will apply in all the cases. Now, whenever you file INC 22 for your verification of new address, don't you think you have to give address proof? Address proof you have to attach now. So every time you file INC 22, you have to attach address proof. For example, if you own that address, that building, then you have to give title deed of the premises. If you have taken on rent, then you have to give rent agreement. Or if you are using it with the permission of owner, then you have to give NOC of the owner. And utility bills also you have to give not older than 2 months. Guys, every time this attachments are always attached along with INC 22 in all the four cases. In all the four cases, whenever you file INC 22 to ROC, always you have to give the address proof. Always you have to give the address proof. That is, you have to attach this or this, and you have to attach the utility bills of not older than 2 months. Are we clear with this? Okay, and now don't you think ROC will certify the new address and ROC will register the new address? And now finally ROC will certify your new address and issue fresh certificate of incorporation within 30 days. And from this date, new address will be effective. From the date of RD approval, no. From the date of SR, no. The new address will be effective from the date when ROC registers the same and ROC issues fresh certificate of incorporation. And that's all about the process of shifting of registered office from one state to another. Lengthy but easy. Lengthy, a little bit lengthy procedure, but easy, not very technical. Can we read it from the material? Please come here. Case number 4. First of all, it is given in 13.4, 13.5, 13.6, 13.7 plus rules. It is given in section 13 subsection 4, 13 subsection 5, 13 subsection 6, 13 subsection 7 and rules. Okay. Acha, what is given in 13 subsection 2 and 13 subsection 3? Alteration of name. Alteration of name clause of MOA. And then 13, 4, 5, 6, 7 talks about alteration of registered office from one state to another. Now come here. What does this? First of all, what approvals do we need for shifting from one state to another? SR, BR and RD approval. Now here, now you don't need to specifically mention BR. Why? Because it is implied. Whenever you need to pass SR, so BR will be automatically there. You don't need to mention it specifically. Are we clear with this? So you can say what approvals do we need? We need shareholders approval, SR, and government, central government approval. That much you can say. So the change of registered office from one state to another involve, first of all, it involves alteration of MOA, and this change can be affected by which approvals? Special resolution passed by the company, which must be confirmed by the central government power delegated to RD. Central government power delegated to RD. Now, don't underline this. Directly come to the step-by-step procedure. Step-by-step procedure of shifting of registered office clause from one state to another. From one state to another. From one state to another. Now, this now they have given in very detail. Like, remember how to study. Go, walk to the class, sit down, open your bag, take out your book, keep it in the desk, open the cover page. Now this step-by-step procedure is given in like very detail, one by one. How? Issue notice of board meeting. Don't do anything extra now what we have not underlined. Only do the underline part. Even if you underline, that's fine. You don't highlight, you just underline, that's fine. This. Send notice to board meeting. Send notice for board meeting. To whom? Of course, to board of directors. Guys, Just like when you hold a general meeting, you have to invite all the shareholders. Similarly, when you hold a board meeting, you have to invite all the directors. How you invite all the directors? You prepare an invitation, which is known as notice. So you send a notice to all the directors for calling a board meeting. Now you will hold board meeting. What you will do in the board meeting? You will pass board resolution. For what? You will pass board resolution for calling general meeting. For first of all, you will pass board resolution for approving the shifting of registered office from one state to another. Yes or no? Yes or no? Yes, you will pass board resolution to approve the shifting of registered office from one state to another. First, board will approve it. Now you will pass board resolution to approve the notice of general meeting, and you will also fix the date. You will also decide the day, date, time, and place of meeting. Day, date, and time and place of meeting. Also, you will authorize a particular either director or company secretary to sign all the documents and call general meeting. Guys, all the board of directors, by passing BR, they authorize a particular director, let's say Mr. A, or a company secretary, to delegate him all the responsibility for calling the general meeting. Are we clear with this? Yes. For example, let's say my family is planning my wedding, so all my family will do a meeting. Father, brother, mother, sister, everyone. Okay. Now they will do a meeting, and by meeting they decided that they are giving the responsibility to my brother to book the catering and the photographers, so by meeting all the directors, what they did, they gave responsibility to a particular director. All my family gave responsibility to my brother, that now you will handle the catering and, let's say, the photographer. Are you understanding? So here all board of director will do a meeting, and by passing BR, they will authorize either a director, or either a particular director, one single director, or a company secretary, to they will authorize him to issue notices of the general meeting and to call general meeting and to sign all the documents. Are we clear with this? See, guys, please understand one thing. In all the documents of the company, do company have to sign? Yes. But company can sign kya? Because company don't have hands. Company have hands to sign kya? Company don't have hands to sign. So on behalf of company, who will sign? Directors. But the question is, let's say there are 10 directors in a company. A, B, C, D, E, F, G, H, I. There are 10 directors in a company. So in every document, all 10 directors will sign kya? Of course not. One or two directors will sign. So what happens now? Whenever we have to do any particular thing, let's say we have to call general meeting, we have to shift our registered office, we have to appoint director. Whenever we have to do any activity, all board of directors do a meeting, and by doing voting, they delegate that responsibility to one single director, to a particular director or a particular company secretary, that we all directors hereby give you power that on behalf of all of us, you can sign the documents of this general meeting. You can sign all these documents relating to shifting of registered office. You're not understanding? Yes? No? Not understanding? Okay. I'll try to explain again. What's your name? Pratishtha. I'll try to explain again. Anyone else who's not understanding? Girish? Yes? Shrikar? I'll try to explain this particular point again. This is not relating to this topic. General point I'm telling you. See, whenever, let's say, company is entering into contract, do we have to sign this document? Yes. Let's say I am entering into contract with Harshita. I'm entering into contract with Harshita. Do we both have to sign this document? Yes. I will also place my signature here. Harshita will also place her signature here. In every contract, both the parties have to sign the document. Okay. So let's say here company is entering into contract with a person. Company has to sign this document. Yes or no? Yes. Company has to sign this document. But company is the artificial person, right? So company don't have hands. So in order to sign all the documents on behalf of company, and in order to manage the company, we appoint certain people. They are known as directors of the company. Okay, so there can be somewhere between 1 to 15 directors in a company. Private company may minimum 1, maximum 15. Public sorry, OPC minimum 1, maximum 15. Private minimum 2, maximum 15, and public minimum 3, maximum 15. So let's assume there are 15 directors in a company. Okay, Mr. A, Mr. B, Mr. C, D, E, F, G, H, I, J, K, L, M, N. These 15 people are the directors in a company. Now, guys, of course, if we have to sign any document on behalf of the company, directors will sign, but obviously all the 15 director will not sign. So together they will do voting. All 15 director will do voting, and by passing board resolution, they will decide, they will give this responsibility to a particular director. So all these directors will do a voting, and by voting, let's say they decided together name of Mr. A. All of us together, we are giving this responsibility to Mr. A. We are giving this power to Mr. A, that on behalf of all of us, on behalf of the company, Mr. A can sign this document. So we give this signing power to a particular director by passing board resolution. By passing board resolution, all the directors give power to a one single director or a company secretary, that yeah, we are giving you power. You can sign on this document on behalf of the company. You getting now? Pakka? Okay. So my point is, guys, coming back to the topic, here we have to sign a lot of documents in relation to company. We have to sign notices, we have to sign minutes of the general meeting, all the documents. So to sign all the documents, board of directors will do a board meeting and will pass a board resolution. And in that board resolution, they will authorize a particular director or company secretary to sign all the documents. You got this point now? And they will also authorize a particular director or company secretary to issue the notice of the general meeting and to call the general meeting. Basically, they will give them, that person, the responsibility of calling the general meeting. Now, we have issued notice of board meeting, and then we have called board meeting and passed BR. Now what we'll do? We will issue notice of general meeting, EOGM. EOGM means extraordinary general meeting. What is extraordinary general meeting? We will do this in general meeting chapter. Just understand, it is a type of general meeting. So now we will invite everyone for the general meeting. Come to the meeting, come to the meeting, come to the meeting. So we will issue notice of the general meeting, and then now we will hold general meeting. Now we will hold general meeting, and what we will do in the meeting? Havan? No. We will pass special resolution. We will pass special resolution. And in special resolution, what permission we will give? We will pass special resolution for what purpose? We will pass special resolution for shifting of registered office from one state to another. Okay, and authorize director or CS to sign all the documents. Again, they will also authorize a particular director or CS to sign all the documents. Now, Fevicol, guys, it should immediately come to your mind whenever there is SR, there is MGT 14. Whenever there is Deepika Padukone, there is Ranveer Singh. Any more examples? Yes. So whenever there is a special resolution, there is MGT 14. So now, since we have passed special resolution, we have to file MGT 14. It is an e-form. E-form means electronic form, PDF form. You don't have to actually print it out and post that form to ROC. No, it's not a physical form, guys. All the forms are not physical form. You don't have to take a printout and file it to the ROC. It's an e-form. E-form means electronic form. PDF is there. You can upload the PDF in the website. That's enough. Are you understanding? So now you have to submit e-form MGT 14 to ROC. Why? For passing special resolution within 30 days of passing special resolution. Within 30 days from the date of passing special resolution. Done? Guys, board meeting done, BR done. General meeting done, SR done. Now what we have to do? We have to do newspaper publication. So before point number 10, guys, please come to point number 11. Now we have to do newspaper publication. Now come to point number 11. The company shall read the language, so that you write in proper language in examination. You don't write in a very tuta-futa language. Yes, so read the language again and again of the material, how it is written in the material. See, the company shall means, of course, compulsory. The company shall not more than 30 days before the date of filing application to RD in the form number INC 33 23. Huh? Not more than 30 days before means within 30 days only you have to file. Guys, just an example. If we are filing application to RD on 31st of January, if we are filing application to ROC RD on 31st of January, then when can we make newspaper publication? Option number 1, we have to make newspaper publication between 1st January to 31st January, or option number 2, we have to make newspaper publication at least before 1st January. That is, in December, lastly by 1st January, we should do the publication, or between 1st January to 31st January. Option 1 or option 2? Option 1. Some people are saying option 2. Some people are saying option 1. Before 1st January. Read it again. Read it again. Read it again. Simple English is written. Simple English. Not more than 30 days before the date of application, you have to do newspaper publication. What does it mean? Simple English, just decode the English language. It means that you have to make newspaper publication within 30 days before the application, and not before 30 days, which means if you are making application on 31st of January, then newspaper publication cannot be made before 1st of January. Newspaper publication has to be made somewhere between 1st January to 31st January. This is just a decode interpretation of this English language. Are we clear with this, everyone? Guys, the company shall not more than 30 days before the date of filing application do what? Advertise public advertisement, guys, in the form number INC 26 in two language, in vernacular newspaper in vernacular language, which is circulating in all the district, and in English language in English newspaper, which is circulating in all the state. Guys, one small correction in the notes. One small correction. This vernacular newspaper has to be circulated. I'll make one small correction. English newspaper has to be circulated in the state, and vernacular newspaper has to be circulated only in the district. Small correction. This small details actually matters. This small details actually matters. It was my mistake. I'll just quickly correct it. Guys, the vernacular newspaper means local newspaper in which you will publish, that has to be circulated in all the district, which means if you're shifting your registered office from Bangalore to Mumbai, then you have to publish it in one Kannada language newspaper, which is getting circulated in all of Bangalore, in all the district. Are we clear with this? And also you have to publish it one English newspaper, and that English newspaper should be circulated in all of the Karnataka. That English newspaper should be circulated in all the state, and that vernacular newspaper should be circulated in the district. See here, it is written, you have to make advertisement in the form number INC 26 in vernacular newspaper in vernacular language. Vernacular means local. Vernacular means local newspaper in local language in the district, which is circulated in the district. And no, I'll come again. And also you have to publish in one English language in English newspaper having wide circulation in the state. Guys, I was correct only. What is written here now, that language should be local in that district. Here they are saying that you have to give district ka local language. What is here Bangalore ka local language? Kannada. So you have to publish in Kannada newspaper, but both the newspapers should be circulated all over state. So you know what? The earlier what was written was actually correct. So I'll again correct it. Yes. Wapis back to pavilion. Yes, just interpretation, guys. Now, don't you think to some people you have to specifically send individual notice? Yes, now you have to serve notice by how you can send? registered post, speed post, government service, Indian post service, speed post or registered post you can send. Now you have to send by registered post to each debenture holder and each creditor of the company. You have to send to each creditor and debenture holder of the company. And also you have to send, serve means send, serve means send. You have to send by registered post to ROC, SEBI or any other regulatory body. Acha, SEBI only in case of listed company. See, SEBI you have to send only in case of listed company, and any other regulatory body if the company is regulated by any other law. If company is regulated by any other law also, then by any other regulatory body. For example, if it is an insurance company, then it is regulated by Insurance Act also. In that case, we have to send notice to IRDA also, Insurance Regulatory and Development Authority. Are we clear with this? Now come back to the point number 10. Newspaper publication done, guys. Now we will make application for shifting of registered office to RD. To whom we will make application? We will make application to RD in the form number INC 23 along with following attachments. Attachment means these documents you have to attach along with the form INC 23. What are the documents? Copy of MOA and AOA along with alteration. Along with alteration means the new altered MOA also. Copy of special resolution, minutes of general meeting, copy of board resolution. All these points were there in the notes. All these points were there in the notes. Copy of board resolution, copy of special resolution, minutes of the meeting. Next, list of the creditors and debenture holders. List of the creditors and debenture holders. This done, this done. Done, done, done. Now, come here. We have to also attach affidavit verifying list of creditor. Affidavit means shapat patra. Shapat patra means it means affidavit is a kind of written official declaration which is signed, where we say that all the information are true and correct. It is not false. So when anything is supported by affidavit, it becomes official. It becomes official. So we have to give affidavit verifying list of creditors, means we have to give affidavit where we will write all the list of creditors and debenture holders are true and correct. So we have to give affidavit verifying the list of creditors. And guys, next, point number 5 and point number 9 is same. We have to give a list of creditors and debenture holders by drawn up to the latest date preceding the date of application by not more than 1 month. What do you mean by this? Drawn up to the latest date by not more than preceding the date of application by not more than 1 month means you have to take the list of debentures and debenture holders and creditors not older than 1 month. Not older than 1 month means we have to prepare a fresh list of the current details. Current, who are your creditors and debenture holders now or in the last 1 month. You cannot give list of creditor and debenture holders of 1 year ago. You have to give the latest list of creditors and debenture holders of not older than 1 month. Not older than 1 month. And in the list, what you have to give? Name of creditors, address of name and address of every creditors and debenture holders, and the amount due to them. You have to give, let's say we have taken loan of 10 crore from SBI. So we have to give name SBI, their address, and then amount 10 crore. Are we clear with this? In the list of creditor and debenture holder, what we have to give? Name and address of the creditors and debenture holders and the amount due from them. So point number 5 and point number 9 is same only basically. Next, you have to give details of objecting creditor or debenture holders. If anyone has any objection, then you have to give the details of objecting creditor and debenture holders who has objection, who are having objection with this particular shifting of registered office. Next, if any prosecution is going on against the company, prosecution or inquiry or inspection. Prosecution means criminal litigation or criminal case. Prosecution means criminal case. Inquiry inspection means if government suspect any fraud, then government does inquiry inspection of that company. So if any prosecution or inquiry inspection is pending, then we have to give the details of that prosecution or inquiry inspection also along with the form INC 23 and a copy of the notice published in two different newspaper. A proof You know what? You have published in two newspaper, you have to take a cutout of that newspaper. Cutout. Cutout of that newspaper publication wherever you have published in the newspaper, and a copy of that also you have to attach along with the form INC 23 as a proof. We are showing proof to RD. See, we have done newspaper publication. This is the copy of newspaper. See, as a proof. As a proof to RD ki see, we have done newspaper publication. So you have to attach copy of notice published in two different newspaper. Are we clear with this? Next is your point number in 10. Affidavit. Affidavit signed by, who will sign the affidavit? CS. CS, if any. If any means if there is CS in the company, then it has to be signed by CS. And not less than two director. Not less than means minimum two director. If more than two director wants to sign, then well and good, but minimum two director. Out of which one shall be MD. Out of which one of whom shall be MD. One of whom means out of the two directors, one shall be MD. Where there is one. Where there is one means if there is MD in a company. If there is no MD in a company, then normal two directors. So out of one shall be MD where there is one. Where there is one means if there is MD in the company, then it should be one MD. What they will declare? They will declare that they have made full inquiry into the affairs of the company, and they have formed an opinion that list of creditor is true and correct. List of creditor is true and correct. So here they will give a declaration. CS and two director will give a declaration that we have done detailed inquiry of the company, and we are of the opinion that list of creditor and debenture holder that we have provided you is true and correct. Secondly, the estimated value of the list of debt that we have given you are proper estimate. The value of the debt that we have given you, that is also true and correct. That is also proper estimate. Are we clear with this? The third declaration that we have to give is affidavit from directors of the company that no employee will be retrenched. We have to give affidavit that employees will not be removed from the company. They will not be removed. They will not be retrenched. Affidavit from the director that no employee will be retrenched as a consequence of shifting of registered office. And a copy of acknowledgement of service of copy of application to the registrar and the chief secretary of the state government that none of the employees' interest will be affected. Guys, what does this mean? Language is a little technical. Guys, you have to send a copy of application. Sorry, copy of application means your INC 23 ka copy you have to send to registrar also, ROC also, and chief secretary of the state government also. The copy of application you have to send to ROC and chief secretary of the state. And acknowledgement of service. Acknowledgement of service means acknowledgement that you have already sent a copy of application to ROC and chief secretary. This acknowledgement you have to send to RD along with application, along with INC 23. Along with INC 23, you have to tell RD by giving an acknowledgement that yeah, we have already sent a copy of application to ROC and chief secretary of the state. So you have to give acknowledgement that you have sent. Service means send. Service means send. You have to give acknowledgement that you have already sent a copy of application to ROC and chief secretary of the state. This you have to attach, this acknowledgement you have to attach. I think this many documents attachments are more than enough. 2-3 are left that you can skip and ignore. Are we clear with this? Now RD will either approve or reject within how many days? 15 or 60. If no hearing, no objection is there, then 15. If objection is there, then 60. Now come here. Where there is no objection is received from any person, which means if no objection is received, then the application may be put up for order by RD. Application may be put up for order by RD without hearing. Without hearing means no hearing has to be done. Hearing need not be done. Either approving or rejecting the application. What RD will do? Either approve or reject the application, and that order shall be passed within how many days? 15 days of the receipt of the application. Easy. Next, if objection is received, then central government. Here central government means RD. will hold the hearing of both the parties. Hearing will be done, both the parties will be allowed to speak. And central government will pass the order approving the shifting within 60 days of the application. That means if hearing has to be done, then RD will pass the order within how many days? 16 days. So RD will either approve the application or if no consequences reached at the hearing of the company. See, if consequences reached at the hearing, consensus, sorry, consensus means no, consensus means mutual agreement, you can say. Consensus means consent. Both the party agree to this. So if, let's say, those who are objecting, the creditors or the employers, those who are objecting, if they have reached the consensus, means they have agreed to the shifting. Consensus has reached. So if consensus has reached, then RD will pass order approving the shifting within 30 days. Okay, consensus has reached means creditors, those who were objecting, they now they are agreeing to the shifting. Now they are not objecting. Consensus has reached. However, if no consensus has reached, means they are still not agreeing. Creditors are still not agreeing. No, 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 we don't want the shifting. If consensus has not reached at the hearing, the company shall file the affidavit in which the objection to be resolved within the definite time of the frame, duly reserving the original jurisdiction to the objector for pursuing its legal remedy even after the registered office is situated, and upon execution of which central government will pass an order either confirming or rejecting the alteration within 60 days of the application. So here in this particular case, if consensus is not reached, if both the parties are not agreeing, company is saying that we will still shift the office, and creditors are still not agreeing, we don't want the company to shift the office, then depending upon who is right, central government will either approve the shifting or reject the shifting. If company is right, then central government will approve the shifting. If creditors are right, then central government will reject the shifting. Within how many days central government will pass order? 60 days. Here central government means RD. Here also central government means RD. Okay, but in the first case, since consensus is reached, so there is no doubt now creditors are also agreeing to the shifting. So in this case, our ROC will approve the shifting within 60 days. Now in this case, if hearing has to be done now, then 60 days time limit is there because a little bit more time is needed. However, if no objection is there, then simply our RD can approve or reject within 15 days. Are we done? Now RD has passed the order, and let's say RD has approved the application. Now we have to file two forms to ROC, INC 28 and INC 22, which is where here, if you'll come, the copy of order of central government shall be filed approving the alteration shall be filed in INC 28 to the ROC along with the fees within 30 days from the date of receipt of the order. When you will receive order from central government, within 30 days you have to file INC 28 to RD. Also you have to file INC 22. It is not given anywhere. Kya INC 22? Point number 18. Oh yes. Come to point number 18. Once the order is passed by RD, now you got the approval to shift the registered office. Now you have to file form number INC 22 for verification of registered office to registered of ROC. And along with INC 22, you have to attach certain documents. What are those documents? Proof of address, basically. For example, if you own the premise, then you have to give the document of title of the premise. If that premise belongs to you, you are the owner, then you can give document of title. If you have taken it on lease or rent, then you can give lease or rent agreement. Or if simply you are using that building from the permission of owner, then you can give authorization from the owner or NOC from the owner regarding of the premises for using that premises. Also along with that, you have to give copy of utility bills, for example telephone bill, gas bill, electricity bill, water bill, etc., which should be not be older than 2 months. Guys, this documents are attached in all the four cases. In all the four cases, you have to file INC 22. In all the four cases, these documents you have to attach along with INC 22. And with this, we are done with the process of shifting of registered office. Lastly, ROC of both the state will approve the forms and change in registered office. ROC of both the state will approve the change in registered office, and they will approve the form, and the will be updated in the register of company with the registrar, and new certificate of incorporation will be issued by the register of state within 30 days, where the company's registered office is going to be shifted. Who will issue new certificate of incorporation? Bombay office. For example, if you are shifting from Bangalore to Bombay, then Bombay's ROC will issue new certificate of incorporation. So the ROC of that state where we are shifting will issue certificate of incorporation within 30 days, and from date of new certificate of incorporation, the change of address will be effective. The change of registered office will be effective from the date when ROC registers the same and issues fresh certificate of incorporation. That's all. Now, don't you think here, when we shifted from one state to another, MOA altered? So in every copy of MOA, we have to make the changes. Yes. So now there are some steps after obtaining certificate from ROC, means after alteration, after shifting, there are some additional things which you have to do. After shifting, what you have to do, you have to alter your MOA, and with respect to state, in every copy of MOA, in every copy of MOA you have to update the name of the state. In every stationery, in every banner, signboard, bills, invoices, boards, even stamp, everywhere you have to update the new address. Everywhere you have to update the new address. In all the documents, bills, letterheads, notices, stationery, everywhere you have to update the new address. And you have to make necessary changes in letterhead, books and records. Same only. Second and third point is similar only. Every books, every record, every letters, every bill, every banner, stationery, everywhere you have to update the new address. Bank also, yes, everywhere you have to update the new address. Okay. And you have to inform about that a change of address to all the government departments, banks, customer, and all other. You have to inform about your change in address to your bank, to government, to your customers, and to all other people who are associated with the company. That's all. And with this, we are done with shifting of registered office from one state to another. A little lengthy, but easy to understand. Now, you have to properly learn the whole step by step procedure of all four cases. First two cases is to nothing. Third case is also easy, a little, only a little more than first two case, and fourth case is lengthy. Fourth case is lengthy. We have done the same from the notes also, and we have also read it from the material also. Proper in detail. I have invested more than required time to this topic. More than required time to this topic. Now I am done from my end. Now what you have to do from your end? From your end, this PDF is already sent in the group. First, after going home, open the material. Along with reading the material, read the notes also and read the material also. Side by side, every topic. One topic from material, from notes. Understand it from your own. Explain it to yourself. This. Understand on your own. And then learn it. Learn it properly so that you'll be able to tell whole process without looking at the book. Learn the whole step by step procedure. Learn it and then close your book and tell whole procedure without looking at the book. And if still you are not able to understand any point, you can ask me after the class. After the class, if still there is any point which you are not able to understand, ki, ye still I didn't understand this point, then come to me and ask to me after the class. That is your responsibility. If you will not ask, I will assume that you have understood. Those who have doubts, those who don't understand any topic, they come to me after the class and ask the doubts. So if you're not asking doubt, what I will assume? That you have understood the topic. Are we clear with this? So this topic is important from examination point of view, and we have done this in very detail with all our heart and brain. Now you have to justify this topic from your side also. Now you have to do what is required from your side. Are we clear with this, everyone? Okay. Guys, in case number 3, where state is not changing but ROC is changing, for example, Bombay to Pune, do we have to make newspaper publication? Yes or no? No, we don't have to make. In the fourth case, when we are shifting the state from one state to another, do we have to make newspaper publication? If we are changing, very quick answer, na? Quick, fastest finger first. We are changing registered office. We are changing registered office from Bombay to Pune. ऐसा required or not? Yes or no? Yes, ऐसा required ना? Yes. Okay. We are shifting the registered office from same city, town or village. RD approval required or not? No. We are shifting registered office outside the city, town or village, but ROC is not changing. RD approval required or not? No. ठीक है. Good. Passed. Not now. After some time. Let's complete this topic and then we'll have break. Okay. Now, guys, we are done with Companies Act. We are done with section 12 and section 13, which talks about alteration of registered office. Now, there are some case laws. These are some past exam case laws relating to this topic. Now, let's just read this case laws. Case laws now don't by heart, just understand. You have to properly learn and by heart the procedures. What is given in the law, that you have to properly learn and by heart. Not exactly line by line, but yes, what is the law, that you have to learn. Case laws you don't need to learn. Case laws you can just go through and understand. Are we clear with this? Some case law is given, let's just read it. No notice of the petition is required to be served on the state, but in the view of wider language, central government may direct the notice to be served to the state if it is of the view that the interest of the state is affected. Remember, guys, we need to specifically serve notice to some people about the alteration. When we are altering the registered office from one state to another, we need to make newspaper publication informing everyone, guys, we are planning to shift our registered office from Bangalore to Bombay, and we have to specifically inform to creditors, debenture holders, ROC, SEBI. Was their name of state government? So if we are shifting our registered office from Karnataka to Maharashtra, do we need to specifically send notice to Karnataka ka state government? No, not required. Law में it is not given. But yes, if central government feels, if central government feels that if central government feels that the interest of state government is adversely affected, then central government may ask the company that you should serve the notice to state government also. Otherwise, generally it is not required, but central government may ask the company to send the notice to state government also if the interest of state government is adversely affected. That's it given here. Ki notice of the petition, no notice is required to be served to state government. No, you don't need to serve it to state government, but central government may direct the company to serve the notice if it is of the view that interest of state is adversely affected. Are we clear with this? Next, when the alteration is affected by change of registered office from one state to another state, there is a loss of revenue in one state would be accompanied by increase in revenue in other state. So in such a case, the interest of particular state might not be considered, but it is in the interest of whole country as a whole which should be considered. What do you understand by this? Not understood? Not understood? What is given here? For example, a company is shifting from Karnataka to Maharashtra. So there will be loss of revenue of Karnataka state government, because earlier we were paying, let's say, SGST to Karnataka government. Now we are shifting to Maharashtra. Now we will be paying SGST to Maharashtra government. So there is a loss of income of Karnataka government. but simultaneously there is an increase in income of Maharashtra government. So law says that can government deny, can central government RD deny ki no, 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 you can't shift your registered office from Karnataka to Maharashtra just because there is a loss of revenue of Karnataka government? No. Why? The reason is we will not consider the interest of state government, but we will consider the interest of India as a whole. So if Karnataka government is losing the revenue, tax revenue, Maharashtra government will gain the taxation revenue. Na? Are you understanding? So overall, if you see India as a whole, so India as a whole, it is an interest only. It is not affecting India as a whole, although it is only affecting Karnataka government. So this is not the reason why government will, reject the application. So government will not consider the interest of only one state. Rather, government will consider interest of India as a whole. So even if we are shifting a company from Karnataka to Maharashtra, as a result, Karnataka government is losing the tax revenue and Maharashtra government is increasing the tax revenue. Then also government will not reject the application. Government will allow the rejection even if Karnataka government is facing loss of revenue. Are we clear with this, everyone? Now got the point? Now understood? Okay. Now come here. See, similar case law is given here. We will read what is given here. There is a case of Satya Shri Balaji Wires and Cables Private Limited. The decision to shift registered office from one state to another, it is a domestic matter and rest with shareholders. Means it is a personal matter and it should be decided by shareholders. And the company is the best judge how to run the business economically, efficiently, and conveniently, even if it would result in the loss of revenue to the state. What we are saying that company is owned by shareholders. So shareholders are the best people to decide from which state we should operate and which is the best to do. Shareholders are the one to decide how to run the business more effectively. It is not government to decide. So even if there is a loss of revenue to state government, then also central government will allow the shifting of registered office because ultimately it's the decision of shareholders, not the loss of revenue of state government. That's all. So basically repeated only. Now a company was allowed to shift registered office from Bihar to West Bengal. There was a company, Usha Beltron company. It was shifting its registered office from Bihar to West Bengal. So it was allowed in spite of the fact that Bihar government has granted lease to the land of company factory on a condition that it would not shift its registered office. So the CLB, CLB is a company law board. NCLT was earlier known as CLB. Now which is NCLT now, the earlier name of NCLT was CLB, company law board. So the CLB held that interest-free loan, sales tax, electricity, and other subsidies would have no bearing on the shifting of the registered office. You know what has happened here? There was a company, Usha Beltron. That company was running in Bihar, and Bihar government also gave them a land on lease. The land on which that company Usha Beltran was working, that land was taken on lease from Bihar government. So Bihar government was getting what? Rent income they were getting, lease income. And when Bihar government was giving this lease, land on lease to this company, Bihar government made a condition: we will give you land on lease only on one condition, that you will not shift to any other state, you will stay here in Bihar only. Even after that, that company shifted to West Bengal. Is that okay? Yes. You cannot do such a condition ki you can't shift. Company can shift, they have right to shift. State government cannot tell you that you cannot shift to any other state. Are we clear with this? State government cannot tell you you cannot shift to any other state. It's like ki your husband and wife cannot tell you you cannot divorce me. It's their right. If they want to take a divorce from you, they can take divorce from you, which is in trend basically. Are we clear? Yes, everyone. So even if in this case Bihar government took a, gave a land on lease to this company on a condition that you will not shift, then also the company can shift. Here loss of revenue of Bihar government, that they will lose rent income, they will lose taxation, they will lose electricity income. Even after they will lose all this income, this will have no effect on the shifting. Still central government will allow the shifting of the company from one state to another. Are we clear with this case laws, everyone? Yes. Now before going to object clause, one last case law of Bharat Commerce and Industries Limited. There is this case law of Bharat Commerce and Industry Limited. In this case law, we are discussing whether employee have right to object to the shifting or not. Whether employees have right or not to object to the shifting. Yes, they have right. They have right that they can object only if they are removed from the company or they are retrenched. Let's say company is removing you. Company is saying that we are going from Bangalore to Karnataka. So company is saying all the Bangalore employees, we will not take you to Maharashtra. We will not give you job there. We will give their job to local people there, Maharashtrians. Can employee of this company in Karnataka can object to the shifting? Yes, they can. But let's say if company is giving them equal opportunity in Maharashtra also, company is saying you come, you shift to Maharashtra, we will reimburse you, we will give you the same package, we will give you job there also. Now, are they removed from the company? No. They are getting the job there in Maharashtra also now. In that case, they can't object because they are getting equal opportunity there in Maharashtra also. They are given job, they are offered job position, the same position there also. Now they are, since they are not removed, they are not retrenched. Now they cannot object. So this is decided in one case law by the court. So this is a case law. Please read your employee's right to object to the shifting of registered office from one state to another. Now what is given here in the case of Bharat Commerce and Industries Limited? In the case of Bharat Commerce and Industries Limited, employees union. Employees union means a collection, group of all the employees. Group of all the employees is known as employees union. So the employee union, which was a registered body, which represented a quite number of employees at the register office. They would have legal standing. Legal standing means they would have legal right. Legal standing means legal right. They would have legal standing means they have legal right to appear before the court and oppose the application of the shifting on the ground that their interest is adversely affected. So if their interest is adversely affected, then yes, employees have right. Then they can object the shifting of registered office from one state to another, or on the ground that their interest is adversely affected. However, if the resolution for shifting of registered office, if the resolution for shifting of registered office from one state to another is confirmed by the court. However, it was held that employees union cannot oppose on the ground that there will be loss of revenue or unemployment in the state, or that the meeting at which SR is passed was not valid, which means that employees cannot argue that state will lose their money. Employees cannot argue this. So if let's say I'm the employee in a company now here in Bangalore, and that company is shifting to Maharashtra, can I object to shifting? Yes. If my interest is, as an employee, my interest is adversely affected, then I can object as an employee. I can object to the shifting, saying that my interest is adversely affected. My interest is adversely affected, so I can object to this alteration. But can I object to this shifting by saying that the government will lose their revenue? No, I cannot put this defense. I cannot use this excuse कि government will lose their revenue. That's why I don't want. That's why I'm objecting this company to shift from one state to another. No, that is not a valid reason. And you also cannot say that the meeting is invalid, special resolution is invalid. All this reason you cannot say as an employee. As an employee, you cannot use all this reason to oppose the shifting. As an employee, you have right to oppose the shifting only on one ground, that your interest is adversely affected. Are we clear with this? So employee can oppose to the shifting of registered office from one state to another on the ground that their interest is adversely affected, but they cannot oppose on the ground that government will lose the revenue or meeting is invalid, SR is invalid. Are we clear with this? Yes, sorry, everyone. Yes, so this is the case law. Rest to case law, I'm giving you homework, just read it. Okay. Case laws only. Law we have discussed completely. Companies Act. These are some past court cases. These are some past court cases. One case is of Metal Box India, and another case is of Quality Ice Cream. Quality Ice Cream, have you had? Pathetic ice cream. They put so much of palm oil in that ice cream. So many of bad reviews have come. Like if you will keep that ice cream for a day, all the ice cream will get separate, and all the palm oil, you will, if you will pour it like this, all the palm oil will come separately. Like in their ice cream, the milk quantity is less, and the other preservatives and the palm oil and the sugar quantity is more. I'm not a dietitian or like a okay, physician. No, I'm not that. I just read it somewhere. So This is the case of Quality Ice Cream. Just read, and this is the case of Metal Box India Limited. And with this, we are done with the alteration or shifting of the registered office. Bolo Radhe Radhe. Jai Mata Di. Jai Shri Ram. Jai Balaji. Any other? Jai Maheshmati. Jai Maheshmati. Till now, how's the chapter? Easy, medium, hard? Easy. Easy, medium. Very nice. We are doing a little complicated part, but you're feeling it is easy, then you're doing good actually. Thank you. Welcome. Say, ma'am, because of you. Okay. So we'll be moving towards another topic, that is alteration of object clause amendment. Do you need a 5 minutes break? 5 minutes break, and then we'll start another topic. Drink water. Have water. From time to time, na, keep on drinking a sip of water, like little bit, so that your body, when your body keeps hydrated, na, your brain actually works faster. And when your body is dehydrated, now you feel lazy, you feel sleepy, and your brain stops working, and then topic stops going to your head. So that you understand everything in the class, what you have to do after like 15-20 minutes, keep on drinking a sip of water, so that your brain will be active and you'll stay focused in the class, and you'll be able to better understand what is being taught in the class, and you'll not sleep, because this is the theory subject. We are doing a theory subject, na guys. Guys, new president is elected of ICSI, CS Dhananjay Shukla, and Pawan Chandak, CS Pawan Chandak as a vice president. Every year the election is done, and the new president and the vice president is elected of ICSI, and every year it keeps on changing. Okay, let's play game. Who want to come? Yes. Ha, come. Who want to come? Please come. Please come. Easy or hard? As I say, can you draw this? No? It's very easy. Huh? No, no. What are you drawing? No, you have to draw this. Okay, fine. Erase it? Yeah. Now draw. Yes, it's a line. Line you said, na? Ha, it's the word is line. Okay, next will come. Yes. Huh? Abhishek, have you done? I guess you have done, na? You have done. Yes. Darshan, you have not done, na? You have done? Come. We have done. Shrikar, come. Your word is. Don't say now. This is your word. This is the eraser. Now erase. Yeah, now draw. Bus. The word is bus. How to. Acha. Wait. Now let me. I didn't see in this. Na, there is a category. You can select easy, medium, hard. So till now the category was easy. Now I will do category hard. Really hard is also there. Easy is like very easy. Now I'll do hard one. Huh. Who will come now? Yes, come. I forgot your name, my dear. Jeevan. Yes, Jeevan. Clapping for Jeevan. Clapping for Shrikar also. It is a difficult word, a little bit difficult word. This is your word. Array, don't say it. Have you listened it? What is the word? Have you listened? No, na? हाँ ठीक है. Yeah. Use pencil to erase. Yeah. Oh, I got it. So you are a science student? The person said it. Who said it? No, someone said it. Yeah. The word is heater. Oh my God. How did you draw this? Are you a science student? Ideal. Who said heater at first? You very nice. But it's not so cold in Bangalore that you have to use heater here. You feel this is cold. You come to my place. You have to wear 4 layers. It's in Chhattisgarh, Surajpur. My hometown is in there. It's so cold there. I was literally in 3 layers, minimum 3 layers. It's so cold there. Here, I don't have to wear the sweater. Huh? No, I come from a place where it gets too cold in winters. Like at night, it get even 6 degree, 5 degrees, like that. In sometimes even less than that. So it's very cold there. So when I come here, I feel very good. My mother yesterday only called me and said, "Thank God, yet this time you went there in Bangalore. It's getting too cold here." So there, if you'll go north side, center side, also Delhi, if you'll go that side, it's too cold. This is not cold. This is not cold. Yes, because you don't have the habit now to okay. These words are like super difficult. Okay, anyone? I every day I draw one. First, anyone who will come? Yes, the girl in the last Aishwarya, right? Come. Difficult or easy? Okay. This is your word. Is it fine? Oh shit. This is too difficult. Okay, I'll do it. Okay. You cannot use letters now. Okay, I'm not using any letters. हाँ, ठीक. No, not thief. Not suitcase. Yes, yes. The word is delivery. Very nice, very nicely drawn. Clapping for her. Very nicely drawn. Yes. Nandini, come. Have you drawn? Will you be able to draw this? Okay. More words. More words. More words for it. Yes. Festival, no. Exhibition, no. See now, what is there? What do we call? Chain? No, no, no. No. Yes. Who said? Very nice. This the word is carnival. It was quite easy to guess from this. She has drawn it very nicely. Carnival. Okay, and Kajal have guessed it. Very nice. Now, yes, clapping. So excited to clap. Guys, these guys are cheering you a lot. Okay, so how's it feeling like studying on Sunday? Boring life? Boring life of students, just like their boring madam. No? Interesting? Yes, it was amazing. Next level. No, he don't take pictures with audience. There were so many audiences, though it was house full completely. So they don't take pictures. Next time. Next time when I'll go to perform on stage. No, I'm not going to Coldplay because I got your schedule. It's okay. ठीक है. Okay, after the completion of the batch, we'll go somewhere. Here in Bangalore only. And not Goa. I will not go to Goa with students, of course. Yes. Do you guys watch reels? Yes. You do you know any recent trends? Every time there is some trend in the reels, na trend is going on. Do you know any recent trends in the reels? That one, na? Any other trend? You guys, huh? And then throwing, like turning like this, na? That's it. This is the trend. Oh, I don't know about it. I've not seen. Few months back, there was a trend of Lattu Mutyana Sanchare, whatever. Fan, fan. Yes. हाँ, सपने देखना अच्छी बात है, पर सपने को लेकर बैठे रहना और 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 सपने को लेकर सोते रहना, ये तो ठीक बात नहीं है. So there was a meme on relating to this, that his name is Bijoy. Okay. So there was this meme same relating to this, that बुक्स खोलना अच्छी बात है, लेकिन बुक्स को लेकर के बैठे रहना और फोन स्क्रॉल इन रील स्क्रॉल करते रहना, ये तो ठीक बात नहीं है. शुभ रात्रि. नाइस एक्सेंट ना. टैक्स मीम, which one? Nirmala Sitharaman. So there are a lot of memes relating to Nirmala Sitharaman. ऐसे तो 90% of the India will get give tax, because most of 90% are one sided. Any other trend? ट्विटर में फॉर एग्जाम्पल. ओके. ओ. Any trending video in which we can make reel? In that, of course, we cannot. Because that is the reel of two people. Any other trending reel in which we can make some funny reel of group as a whole? Yes. We will make a reel at the end of our today's class. Sunday fun day. We'll make Sunday a fun day. Okay. So if you have any recommendation, then send me and we will make that reel after the end of the class. Okay. Now, before that, we will complete this alteration topic. So we will be doing alteration of object clause. We have done the mountain section. Alteration of rested office. Now rest all will be easy only. Which video? Yes. Rock meme. Which one? I don't know. No, we need a group meme, na? ठीक है. We'll do this at the end of the video, at the end of the lecture. As of now, first we'll complete the alteration topic. Okay. So come here, everyone. Shh, shh, shh. The next topic is alteration of object clause. We are done with alteration of name clause and alteration of registered office clause of the MOA. Two topics are done, three topics are left. Now next is your alteration of object clause. Object means the purpose for which the company is formed. Object for which the company is formed. It is discussed in which section? Section 13 subsection 8 and 13 subsection 9. All the provision about alteration of memorandum is given in section 13. So section 13.2 and 13.3 talks about alteration of name. 13.4, 5, 6, 7 talks about alteration of registered office from one state to another. And section 13.8 and 13.9 talks about alteration of object clause. It talks about alteration of object clause. Now, what do you mean by alteration of object clause? Now, let's say we want to issue DVRs, but power to issue DVRs is not included in memorandum, then we first need to alter the memorandum. We need to include that power to alter alter the memorandum in MOA, and then only we can sorry, once again, what you have to do, let's say you want to issue DVR, but the power to issue DVR was not included in MOA. So can you issue DVR? No, because you can do only those activities which are permitted in the MOA. Now, if you want to issue DVR, then you need to alter your memorandum. You have to alter your memorandum and you have to add this power in the memorandum that company can issue DVR, and then only company can issue DVR. Are you understanding? So from time to time, we may need to alter our object clause. We may need to add some other object or delete some object. Now the first question is, what approvals do we need to alter the object? If you're changing the main objects are the most important clause of MOA. Object clause is the most important clause of MOA. So if you want to alter the object clause, first of all, shareholders approval is needed by way of special resolution. That is the for sure, because for altering MOA you need special resolution approval. So first of all, what approvals do you need? Of course, you need the approval of shareholders by way of special resolution. Then now you need approval of central government. Simply you can apply to ROC. ROC will register your alteration in the object clause. Are we clear with this? So what you have to do, let's say you are a company and you want to alter the object clause. So first of all, you have to pass special resolution. Now you need to apply to ROC, and when ROC will approve and ROC will register the change, then your new object will be effective. Are we clear with this? So first of all, you need to pass special resolution. And guys, Fevicol, whenever there is special resolution, you need to file MGT 14 to the ROC. So first you have to pass special resolution, and then you have to file MGT 14 to ROC within 30 days. Along with MGT 14, you have to attach certain documents: copy of special resolution, notice of general meeting. Notice means invitation of general meeting that you have sent to all the members, uska copy you have to attach, and altered MOA, because MOA is changing. So the new MOA, altered MOA means new MOA. After alteration, the new MOA ki copy you have to submit to ROC. Thereafter, ROC will certify the change within 30 days, and alteration will be effective from the date when ROC registers the change. That's all about alteration of object clause. Easy peasy. Come to the material. Alteration of object clause of MOA, section 13(8) and 13(9). According to section 13 subsection 1, according to section 13 subsection 1, a company may, by passing SR, alter memorandum. First we are talking general provision. 13(1) says that by passing SR you can alter any provision of MOA. Now 13(6) says that a company shall alter its object clause. Whenever we alter object clause, we have to file with registrar special resolution in the form number MGT 14 within 30 days. Guys, whenever we pass special resolution, Fevicol, whenever we pass special resolution, we have to file MGT 14 to ROC. In that, we will file copy of special resolution within 30 days. Sorry. And then ROC will register the alteration and will certify the registration within the period of 30 days from the date of filing special resolution. So what we have to do to alter the object clause, simply pass SR and then file the SR in MGT 14, and then ROC will register within 30 days. That's all. What documents you have to attach along with SR? That is given where? That is given in the process. That is given in the process. Now come here. The detailed process of alteration of object clause is given in rules. Rule 13, read with Rule 32 of the Companies Incorporation Rule. Two rules are there, Rule 13 and Rule 32 of the Companies Incorporation Rule. In these two rules, this is included about alteration of object clause. Sorry. Acha, sorry. Section 13 read with Rule 32. So we are reading Section 13. Section 13 talks about alteration of MOA, and Rule 32 of the Companies Incorporation Rules, and Rule 22 of Companies Management and Administration Rules. Ignore this as of now. Now come here. What is the process? Detailed procedure. We need special resolution approval, but don't you think in order to pass SR, we need to call general meeting? And in order to call general meeting, we need to call board meeting. So first, we will send notice of the board meeting. Notice and agenda of the board meeting. Agenda means list of matters that we will discuss in the board meeting. Now we will hold the board meeting. Now we will hold the board meeting. What we will do in board meeting? We will pass board resolution for approving the amendment of the object clause of MOA. We will pass board resolution to approve the for amendment of the for altering the object clause. We will also pass board resolution to authorize any director to sign all the documents. We will also pass board resolution to fix the day, date, time, place of the general meeting. We will also pass board resolution to approve the notice of the general meeting and to authorize any director or secretary to issue the notice of the general meeting. Are you understanding? They will in board meeting we will take all these decisions. In board meeting we will take decision to alter the object clause. We will take decision to authorize any director to sign the documents. We will take decision to fix the date, time, place of the meeting, to approve the notice of the meeting, to authorize any director or CS to issue the notice of the meeting. Okay. After that, BR is passed. Now, ignore this third point. Now come here. We will send notice of general meeting to all the shareholders. We will send notice of general meeting to all the shareholders. Now in general, we will hold general meeting. Now we will hold general meeting. Now we will hold general meeting and we will pass special resolution for altering the object clause of MOA. Special resolution means 75% approval. 75% approval means 3/4 approval, 3/4 majority. Now since SR is passed, Fevicol, MGT 14. Now after passing SR, we have to file a copy of SR along with to ROC in the form number MGT 14 within 30 days of passing the special resolution along with following attachments. Attachment means following documents you have to attach. What? Copy of SR, notice of general meeting, altered MOA. That's it. Done. Now remove these points and give it point number 8 and point number 9. Attachment is done here only. Okay. Attachment is done here only. Cut this sub points and make it point number 8 and 9 and make a line here. Now ROC will register the alteration of object clause of memorandum and will certify the change within 30 days of the date of filing the special resolution. When ROC will receive MGT 14, within 30 days, ROC will register the change and every alteration shall be noted in every copy of memorandum. Now, you have to make the changes in all the copies of MOA that you have. Let's say we have 5 physical copies of MOA. So, in all the 5 copies of MOA and AOA, we have to make changes in the object of the memorandum. That's all about the process of alteration of object clause. This we already know that no alteration in object clause will have effect until it has been registered by ROC. Guys, if we have passed SR, from that date only new object will be effective. Kya? No. When ROC will register, will approve the alteration, will register the change, thereafter only the new object will be or alteration will be effective. Any alteration of the memorandum in case of company limited by guarantee and not having share capital purporting to give any right to anyone to participate in the divisible profit otherwise than as a member shall be void. Guys, this point is already done. In case of guarantee company not having share capital, we can give dividend only to members. And if we are altering MOA to give dividend to any person other than member, then that will be null and void. This is repeated only. This is already done, so no need to underline this. Now we are left with one point, which is this box. Which talks about alteration of change of object in prospectus. You can write here, it talks about, this paragraph talks about change of object in prospectus. 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 Now, what does this mean? This provision is given in section 13, subsection 8. Now, everyone listen to me. When a company comes up with IPO or public offer, when we come up with public offer where we are inviting general public that whosoever wants to subscribe the shares of the company can subscribe the shares of the company. So when we invite public, ki whosoever want to purchase the shares of the company, you can apply to the company for purchasing share of company. This is known as public offer, open for all, general offer, public offer. We make public offer by issuing a document. That document is known as prospectus. That document is known as prospectus. So whenever we make public offer, which document we issue? Prospectus. In prospectus, the object is given. Object means for which purpose we are raising the money. For example, if we are issuing shares worth rupees 1 crore, we are making offer of 1 crore. How much money? 1 crore. Which means we will issue shares to public and we will raise 1 crore rupees from them. How much we will raise? 1 crore. So in prospectus, we have to mention this 1 crore we will use for which purpose. Okay, with this 1 crore, we will start our new outlet, or we will increase our stock, or we will spend it in marketing. For which purpose you will use this 1 crore? That object you have to mention in the prospectus. With this 1 crore, why we are raising this 1 crore? For this object, for this object. Object means purpose. We will use this 1 crore for this purpose, this purpose. Are we clear with this? Now, if I am raising your money, let's say I'm taking loan of 500 rupees from Janvi, Joshna. I am taking loan of 500 rupees from Joshna. And I'm saying, Joshna, I want to take loan of 500 rupees from you so that I can buy a notebook. So that I can buy 5 notebooks. So you are said ki, acha theek hai, for study purpose you want na, theek, I'll give you 500 rupees note. So you gave me loan because I wanted to use it for some purpose which you are okay with it. So I wanted to use it for buying 5 notebooks. So I told you ki I'm taking loan from you, I'm taking money from you for this purpose, for buying 5 notebooks. So you are like, okay, you gave me the money. Now let's say I took the money and I'm doing gambling with that 500 rupees. Can I do that? No. Or simply, can I use that 500 rupees for eating samosa? No. Why? Because when I took money from you, I clearly mentioned the object. I'm raising this money for this purpose, so that I can use that money only for that purpose. So if I'm taking money from you and I'm saying you, I'll use your money for buying 5 notebooks, then I can use that money only for that object and not for any other object. Now let's say, same example, company was coming up with the IPO of 10,000 crore, or let's say 1,000 crore. We are making IPO of 1,000 crore. That means from public, we are issuing shares and we are raising 1,000 crore. And in the prospectus, we have raised that we will use this 1,000 crore for opening a new outlet and for restocking, for increasing the stock, working capital. We will use this for working capital. Now we can use that money only for these two purposes. Now let's say we raised 1,000 crore. Out of 1,000 crore, 900 crore we used for the same purpose. We are left with some unutilized amount. Unutilized amount, 100 crore is left. Now we don't need in these two purposes. We have already invested 900 crore for these two purposes. Now 100 crore is left. Now we want to use it for any other purpose. Now let's say that 100 crore is left. We want to use it for marketing. But that was not mentioned in the prospectus. That was not mentioned in the object of the prospectus. Are you understanding? So can we use it? No. First of all, whose money it is? Public money it is. So don't you think first of all you need permission from the public? That is your shareholders. You all become the shareholders now. Those who purchase the shares of the company in IPO and we raised your money, you all became shareholders. So it's your money. So if we want to change the object of the prospectus for which money is raised from public and any amount is unutilized, now we want to change the object, then we need shareholders approval by way of special resolution. Are we clear with this? Now let's say you all are 100 people. You all are 100 people. So we need 75, minimum 75% approval. So let's say you all are 75 and you all are 25. Okay. So you all are 75 and you are 25. So 75 people said, yes, we don't have any problem, ma'am. You can change the object. You can use this leftover money, unutilized money for marketing also. So we are allowing you change in object. Can we go for change in object? Yes, because we got 75% approval. What about this 25% approval? Even if these people are saying no, then also we can proceed with the change in object. Why? Because we got 75% approval. In that case, if any shareholder is dissenting shareholder, dissenting means still they are not agreeing. No, ma'am, don't use my money for marketing. I gave my money so that you can use it for this one and two purpose and for no other purpose. So if any shareholders deny or they are dissenting, then company has to give them exit opportunity. Exit opportunity means since we got majority approval, so we are going with the change in object. If you don't want us to change in object, if you don't want us to use your money for marketing, we are ready to give you a refund. We are ready to give you a refund. If you don't want the company to use your money for marketing, we have already got 75% approval, so we are going to use this money now for marketing new object. But if you are dissenting shareholder, you don't want, then company has to give them exit opportunity. Exit opportunity means you can exit, we will purchase your shares back and we will refund your money. The shares that you have purchased by investing your money in the company, what we will do, we will return your money and we will purchase back your share. Who has to give this exit opportunity? Promoters of the company. Promoters or controlling shareholder of the company. For example, Mukesh Ambani has to give exit opportunity to public in Reliance because he's the promoting shareholder or controlling shareholder. So the promoting or the controlling shareholders of the company have to give exit opportunity to the dissenting shareholders. Are we clear with this? Yes. And this is also about the topic of change in object in prospectus. It is given in section 13 subsection 8. What does 13 section subsection 8 says? That if you want to change the object in the prospectus, if there is any unutilized amount, then first of all you need the approval of special resolution. Special resolution means 75% approval of the shareholders. Along with the special resolution, you have to make public notice also, government hindora, public advertisement, because public money is involved na. Prospectus, guys, prospectus ka object you are changing, so whole public interest is involved. In that case, you have to make newspaper publication also. You have to give notice of special resolution in two newspaper. You have to publish it in two newspaper, one in English newspaper, one in vernacular newspaper, and also you have to publish it in the website. And also you have to publish it in the website. Why? Because public interest is involved. You are using public money for some other purpose which was not mentioned in the prospectus. You are changing the object in the prospectus. So you have to make public advertisement so that every public will get to know about it. They will get informed about this. So you have to make newspaper publication, and promoters or controlling shareholders have to provide exit opportunity to dissenting shareholders. Exit opportunities to dissenting shareholders should be given by promoters or controlling shareholder. Exit opportunity means promoter will say, Mukesh and I will say, oh, I will purchase the shares of Reliance from you and I'll refund your money. Refund your money. You can exit from the company. You can exit from the company. This is all about the change of object in the prospectus. Are we clear with this? Let's read it from the book. Please come here. It is given here in this paragraph. Let's read it from the book. Everyone to the material. Section 13, subsection 8. Section 13, subsection 8 says that a company which has raised money from public through prospectus, which means through IPO, public offer, by issuing prospectus, we have raised money from public, and has any unutilized amount out of the money so raised, which means there is any money which is not yet used. There is any unutilized amount, shall not change its object for which it has raised the money through prospectus unless a special resolution is passed by the company. Which means now if we want to change the object of the prospectus, then we need to pass special resolution. Special resolution is needed to be passed by the company. That is not sufficient. Along with that, we also have to do newspaper publication, and also promoters have to provide exit opportunity to the dissenting shareholders. So now, along with that, the details in respect of such resolution, the details of such resolution should be published in newspapers, one in English and one in vernacular language, which is circulated in the place where the registered office is situated. That newspaper should circulate in the place where the registered office is situated. For example, if the company is in Bangalore, then we have to publish it in one English language newspaper, one Kannada language newspaper, which is being circulated in whole of Bangalore. In whole of Bangalore. And also we have to publish it in the website. If company has a website, then we have to publish it in the website also. And after that, dissenting shareholders should be given exit opportunity by the promoters and the controlling shareholders. Promoters and controlling shareholders have to give exit opportunity to dissenting shareholder. Did you understand what do you mean by giving exit opportunity? Promoters have to give exit opportunity to a dissenting shareholder. Are you understanding the meaning of this? Yes, okay. And this is all about section 13, subsection 8. That's all. And with this, we are done with this provision. So, wait, guys, remember this process of alteration of object clause which we have done? This process, in this process, we have skipped the third point. Why? Because this third point is applicable only if we are changing the object of the prospectus. So this third point is only if we are changing the object of the prospectus, then only this third point is applicable, which is same as section 13 subsection 8, which we just studied, which is same as section 13 subsection 8, which we just covered. So we did not a process of change in object clause. So in that process, third point will be there, third step will be there only if we are changing the object of the prospectus. Okay. Next is alteration of liability clause, which is super easy. Okay, guys. Next is your liability clause. If you want to alter your liability clause, then don't you think, let's say you are limited by shares, you want to alter your liability clause. What does it mean? You might want to convert from limited by share to limited by guarantee, or limited by guarantee to unlimited, or unlimited to limited by share. Are you understanding? Just shuffling. So if you are limited by share, if you want to change the liability clause, that means either you want to become limited by guarantee or unlimited. Are you understanding? So these two are two separate type of company only. Company limited by shares is a different type of company, and company limited by guarantee is a different type of company, and unlimited is a different type of company. So if you want to alter your liability clause, that means you want to change your liability from limited by shares to limited by guarantee, then you have to convert a one type of company into another type of company. Are you understanding? Because these two are two separate category of company only, so you have to convert the whole status of the company. And how to convert one type of company into another type of company, that process is given in section 18, section 1818. Section 1818 talks about the conversion of one type of company into another type of company. For example, you want to convert private company into public company, public into private, OPC into private, private into OPC, limited by guarantee into limited by share, limited by share into limited by guarantee, limited by guarantee into unlimited, etc. Are you understanding? For all this conversion, you need to follow a section. You need to follow a section which is section 18. Section 18 talks about conversion of one type of company into another type of company. Are we okay with this? For this, there is a proper chapter, conversion of business entities in SBILL. In SBLL, there is a chapter conversion. There you will study nothing but conversion of private into public, public into private, all this only. Section conversion of section 8 company into normal company, conversion of normal company into section 8 company. All this thing you will study. So basically, guys, if you're altering the liability clause, that means you are changing the company type only. You are changing company from limited by share to limited by guarantee. So you have to follow all the procedure of section 18, which talks about conversion of company. Okay. And also, since MOA is changing, so section 13 subsection 1 says that whenever you are changing any clause of MOA, you need to pass special resolution. So basically, for alteration of liability clause, you need to pass special resolution, and then Fevicol MGT 14, and then since it is a conversion of one type of company into another, so you need to follow the process of section 18 also. That's all. Come here. Alteration of liability clause. Section 13 subsection 1 says that whenever you want to alter the memorandum, you need to pass special resolution for altering any clause of the memorandum. Alter any provision of the memorandum. For altering any provision of the memorandum, you need to pass special resolution. So a company may, by special resolution, alter any provision, alter any clause of the memorandum. That means to alter the liability clause, we need to pass special resolution. Now since we have passed special resolution, we need to file with registrar. Company shall file with registrar copy of special resolution in the form number MGT 14 within 30 days, and comply with the process of conversion under section 18. You can write it down. And comply with the process of conversion under section 18. And comply with the process of conversion under section 18. Okay, done. Now, alteration of capital clause. We will do this in, I don't say that. We will cover this in share capital chapter. Because guys, this is section 61. Section 61 is not of the incorporation chapter. Section 61 is of the share capital chapter. So we will cover this in share capital lesson, rather right lesson. We will cover this in share capital lesson. Okay, everyone, just for your revision, do we need to pass special resolution for alteration of capital clause? We need to pass only ordinary resolution. Why? Because it is not covered in section 13, it is covered in section 61. So if you want to alter the name, you need SR. Yes, plus you need central government approval also. If you want to alter the registered office, except for the first case within the same city, you need SR. Yes, except for the first case, and only in the last two cases you need central government approval also. Okay. If you want to change the object, you need to pass SR. Yes, and you need ROC approval also. ROC will register. If you want to alter liability, then also you need to pass SR, and ROC approval also you need. And if you want to alter capital, then you need to pass OR. And you know what? No government approval needed. No government, because these four are covered in section 13 and this is covered in section 61. Acha, subscription clause, can it be altered? No, no, it cannot be altered. Are we clear with this? Okay, so basically with this we are done with what? Alteration of capital clause. अच्छा, वैसे तो this process of alteration of capital clause we will do in share capital chapter, but when we talk about this process now, 90% of the process is same. Whole board meeting pass BR, whole general meeting pass SR, OR. This is capital clause. So if you'll see here, acha, some points about this alteration of capital clause I will discuss. For this, we have to read section 61 along with section 64. Basically, these are the sections of share capital chapter. It says that if you want to alter the capital clause, then it should be wait, I'm writing here, it should be authorized by AOA and OR. It should be authorized by AOA and OR. You can write it down. Two authorizations are needed if you want to alter the capital clause. If you want to alter the capital clause of the company, then first of all, authorization should be there in the AOA. Remember, I told you that article is the rule book of the company. So a power should be there in the article that a company can issue, a company can alter the capital clause. The power should be there in the article. If power is not there in the article, then you cannot alter the capital clause. So first you need to check the article. In article there should be this power that company can alter the MOA. Then only company can alter the capital clause. Then only company can alter the capital clause. If power is not there in the article, then first you need to alter the article. If power is not there in the article, then first you need to alter the article, include the permission to alter capital clause in the article, and then you can alter the capital clause. So what is the steps? What is the step of altering the capital clause of the company? First you need to check the authorization in the article, whether article permits or not. So if let's say this is your document article, there should be authorization that company can alter the capital clause. If there is no authorization in article, then first you need to alter the article, add this permission in the article, and thereafter only you can alter the capital clause. This much is okay. So for altering the capital clause, first you need to check the authorization in article. If there is no such authorization, then company need to take step for alteration of article of association to insert the clause enabling the increase in the authorized capital. It should be within the limit of the authorized capital. Are we clear with this? Next, Next, we need to pass ordinary resolution, yes or no? How you will pass ordinary resolution? By calling shareholders meeting. In order to call shareholders meeting, you need to call board meeting. Same to same, copy paste. See, you need to call board meeting and you will pass BR for what? For approving for sorry, for increase of authorized capital, you will pass approval of director. What do you mean by approval of director? Approval of director means board resolution. Approval of directors means board resolution. You will pass board resolution for increase in authorized share capital. Next, you will pass BR for fixing date, time, place of EOGM. You will approve the notice of EOGM. You will authorize any director or CS to issue notice of GM. Don't you think this point is same in all the process? In all the process, this point is same. Next, you will issue notice of general meeting and you will hold general meeting and pass OR. Same. Everywhere it is same. The only difference is in all other process we were passing SR. Here we are passing OR. Specifically, I have mentioned also only SR, not only OR, not SR. Only OR, not SR. In exam, don't write it. I'm writing it so that you focus on this. Here there is OR. Now, guys, there is one form. The name of that form is SH7. Why SH? Shares. Because this form is from the chapter of share capital. That is why the form name is SH7. SH stand for shares. SH stand for shares. This we will study again in the share capital chapter. So guys, there is one law. Whenever there is alteration of capital clause, we have to inform to ROC. Guys, everything we have to inform to ROC. Whatever happens, alteration, there is capital clause is changing now. Do we have to inform ROC? Yes. Acha, do we need to file MGT 14 here? No. Why? No SR na. Only OR is there. So do we need to file MGT 14 to ROC? No. There is another form which we have to file here. SH7. Because there is one section 64 in share capital chapter which says that whenever a company alter its capital clause, we have to inform ROC by filing a form SH7 within 30 days. Okay, so because we are altering the capital clause, we have to file a form SH7 within 30 days to ROC along with following documents. What documents we have to attach along with SH7? Notice of general meeting, copy of OR. Yes, altered MOA. Easy only. Notice of general meeting, copy of OR, ordinary resolution, and altered MOA. And then ROC will check and approve the increase in the authorized capital or alteration of capital clause. ROC will approve the alteration of the capital clause. Specifically, they have given you a clarification that you don't need to pass special resolution for alteration of capital clause. OR is sufficient. OR means majority approval is sufficient. You don't need 75% approval for alteration of capital clause. Done. That's all. That's all the process. So basically, we have done the process of alteration of capital clause also, and what approvals are needed, that also we have done. It should be article authorized and it should be approved by OR, and we have to file SH7 within 30 days to ROC. Just three things you can write here in the top. It should be approved by AOA, OR, and SH7 you have to file to ROC within 30 days. Now guys, what we are skipping for as of now, there are 5 ways in which you can alter the capital clause. There are 5 ways in which you can alter the capital clause. These 5 ways we will cover in the share capital lesson. This we are not covering here. Okay, there are 5 ways in which you can alter the capital clause, and that we will do in the share capital lesson. And with this we are done with the alteration of MOA. Guys, read this line. No alteration under section 13. What is section 13? Alteration of MOA. No alteration under section 13 will take effect until it has been registered by ROC under this section, which means that whenever you will change name, registered office, object, liability, capital clause, it will not be effective until and unless it is registered by ROC. So that change of name, change of object, change of registered office, etc. will be effective only after ROC will register the same. Only when ROC will register the change, thereafter only your alteration of MOA will be valid. Thereafter only your alteration of MOA will be effective. Alteration of MOA will not be effective from the date of SR, or it will not be effective from the date of RD approval. No, alteration of MOA will be effective from the date when ROC will register your change in all the alteration. Okay, is this easy? Lengthy but easy. Lengthy but easy. But you know what? With continuous revision, you can make this lengthy also seem short. This lengthy provision will also look short if you will revise it again and again. So the only solution is multiple revision. You have to revise it minimum 2-3 times after going home before tomorrow's lecture. Minimum 2-3 times you have to go through this and learn the proper procedure. Now come here, article of association. Article of association. What do you mean by article of association? Article of association is known as rule book of the company, which contains the all the rules and regulations of the company. So article of association are also known as bylaws of the company or rule book of the company. So article of association is also known as bylaws of the company or rule book of the company. So there's this basic introduction of article, that article of association is a document. It is a legal document, you can say. It is a document that specifies all the rules and regulations of the company, of the company's internal operations. Company's internal operation, how our day-to-day operations will be carried out, all about internal operation, how it will be carried out. So that we will that is article of association. It carries all the rules and regulations about the internal management of the company or internal affairs of the company. Now it is like a user's manual of the company. Like you seen a manual tells you how to use a particular thing. So manual of the company means how to operate the company, how to do the internal management of the company. It is like a user manual of the company, outlining the methodology of day-to-day task. Of day-to-day task means how we will do day-to-day task. All the procedures are given in article, all the rules and regulations are given in the article. Next, article lays out how the tasks are to be accomplished within the organization, including the process of appointing directors and handling the financial records. Articles tells you how you will carry out a particular task. For example, how you will appoint director, how you will maintain registers, how you will maintain documents, how you will issue shares, how you will forfeit shares, process of forfeiting shares, process of issuing shares. All these process are mentioned in article of association. So article of association tells you how you will do the internal management, how you will do the day-to-day affairs of the company, how you will accomplish day-to-day task. How to appoint director, procedure where is given, article, read article. How to issue shares, where procedure is mentioned, article, read article. So whenever company has to do any activity, let's say we have to give dividend, how to give dividend, we have to read article. So every company has their own article where they prescribe the procedures and the rules and regulation of how they will accomplish day-to-day task, how they will carry out day-to-day task. For example, if we have to issue shares, then for that company has to read its article. We have to read company's article. By reading article, we will get to know the procedure of issuing shares, how we will issue shares, and that's how we have to issue shares. So it tells you the how the day-to-day tasks are going to be accomplished. Okay. Definition of article is very simple. It is defined in section 2 clause 5, which says that article means article of association. Wow. Remember memorandum definition. Memorandum means memorandum of association as originally framed or altered from time to time. Article means article of association. Balle balle. Shava shava. Yesu yesu. Yes. So article means article of association of the company as originally framed or altered from time to time in pursuance of this act or any other previous. Same to same. Same definition was in MOA and same definition is in AOA. Now, it also includes the regulation of table F. Table A is written kya? Cut A and write F. Array A is of MOA na. Table F is of AOA. Misprint. So it also includes regulation containing table F in the schedule 1 of the company. And section 5, guys, article ka section is section 5. What was section 4? MOA. Section 5, AOA. Now, section 5 says that article of the company should contain all the regulations of the management of the company. How we will manage the company, about that all the rules and regulations are given in the article. This is very nice line. If question comes now, what is article, then you can write this. You can write this. Very nice line. Ki article according to section 5 subsection 1, according to section 5, article contains article of the company contains all the regulations for the day-to-day management of the company, and that is why they are also known as bylaws of the company or rules and regulations that govern the internal affairs or the management of the company. It also prescribes the rights of the members. What are the rights of the members? That is also given in the article. What rights member have, that is also given in the article of the association. But if you will compare which one is more important, MOA or AOA, then MOA is more important. So which one is supreme? MOA. And which one is subordinate? AOA. So come here. The article plays a part that is subsidiary to MOA. Subsidiary to MOA means secondary to MOA. If you will say which one is supreme, then MOA is supreme and article is subordinate or subsidiary to MOA. Here subsidiary does not mean subsidiary company. Here subsidiary means secondary or subordinate. They accept the memorandum of association as the charter of the company. We already know memorandum is also known as charter of the company. And so accepting it, the article proceed to define the duties, rights, and powers of the governing body. Governing body means directors, as between themselves and the company as a large. So as we all know, memorandum is the charter of the company, but AOA defines the powers, duties, and rights of the directors and shareholders of the company. The memorandum is, as it were, the area beyond which the action of the company cannot go. What does MOA tells you? MOA tells you the area beyond which the action of the company cannot go. Means, let's say MOA gives you this boundary. MOA tells you this list of 20 activities that company can do. Remember object clause of MOA? A company can do only what is permitted in the object. So let's say in the object 30 objects are permitted, 1 to 30, then company can only do those 30 activities, not any other activity. So company MOA gives you the area. Let's say this is the boundary or the area within which company has to operate. If company will do anything which is not permitted in MOA, then that will be known as ultra virus and thus null and void. But can company do any activity which is permitted in the MOA? Yes. So let's say 30 activities are permitted in MOA. Can we do this 30 activity? Yes. That tells MOA. But AOA tells you how you are going to do this 30 activity. MOA tells you what you can do. AOA tells you how you can do. Difference, are you understanding? MOA, let's say MOA is telling you you can issue DVR. Okay. MOA is giving you permission. What you can do, you can issue DVR. AOA tells you how you can issue DVR. Are you understanding? MOA tells you what you can do, what is the area within which company can operate, and AOA tells you now within this area how you will operate. The question what is answered by MOA and the question how is answered by AOA. You got to know the difference between MOA and AOA. Now come here. The memorandum is, as it were, the area beyond which the action of company cannot go, which means a memorandum is the area beyond which the company cannot go. But inside that area, shareholders may make internal regulations for governance as they think fit, and that is known as AOA. Are you understanding now? Inside that area, how we will operate? For that, shareholders will make rules and regulations which are known as Article of Association article. Now, memorandum lays down the scope and power of the company. This though we already know. We are just comparing MOA and AOA. Memorandum lays down the powers and the scope of the company, but article govern the ways in which those objects are to be carried out. What are the objects of the company? Who tells? MOA. Now how we will carry out this object? How? The question how is answered by AOA. So MOA tells you the object and the power, and AOA tells you how you are going to carry out those objects. Process, rules and regulations. Next, the article must be printed, divided into paragraph and numbered and stamped. Same point was there for MOA also. You have to take a printout of your article, divided into paragraph means all the points should be separately given in different para, numbered and stamped. Stamp means stamp duty should be paid in that. We have to properly stamp it. Next, it should be signed by each subscriber of the memorandum. It should be signed by each subscriber of the memorandum. Remember, those who are subscriber to memorandum, they sign MOA. Yes or no? Those who are subscriber to memorandum, they sign MOA, and they also have to sign AOA. Those who sign MOA, they also have to sign AOA. So AOA, it is written, it is signed by subscriber to memorandum. Subscriber to memorandum means those who have signed MOA, they also sign the AOA. So which means subscriber to memorandum, they put their signature on MOA also, and they put their signature on AOA also, along with proper witness. Witness will also be there. An article must not contain anything illegal. Of course, can we write in our article that our company will do murder in this way? No, right? So article must not contain anything illegal. So murder to theek hai, just for fun. But if anything is illegal, nahi. I don't, I mean example. Okay, what I mean to say is, if anything is illegal as per Companies Act, then that also you cannot prescribe. Anything which is not allowed in Companies Act, that also you cannot write in the article. So article must not contain anything illegal or ultra vires the memorandum. Ultra vires the memorandum means article should not be contradictory to MOA. Article should be in accordance with MOA. If any power is not given in MOA, then you cannot give that power in AOA also. For example, if companies are not allowed to issue shares in MOA only, then AOA may you cannot write the process of issuing shares. Otherwise, it will be ultra vires the MOA. MOA may you have not even given permission for the company. You know what? Even if the company wants to issue shares now, that power should be there in MOA. That company can issue shares. Now let's take an example. In MOA, we have not given this power. In MOA, this power we have not given, that company can issue shares. And in AOA, we are writing the procedure. Company will issue shares by following this procedure. Will that AOA provision be valid? No, because AOA is ultra vires the MOA. Ultra vires means what we have written in AOA is beyond the power of MOA, and that will not be valid, because who is supreme? MOA is supreme. You cannot write anything in AOA which is against MOA or which is not within the power of MOA. Okay, so AOA should not be illegal. AOA should not be ultra vires the memorandum, nor AOA should contain anything which is contrary to Companies Act. We cannot write anything in AOA which is against Companies Act, which is violating Companies Act. For example, Companies Act says that a company cannot issue shares at discount. In your PU, you have done na issue of shares at par, at premium, at discount. For example, if share ka face value is 10 rupees, you cannot issue it for 8 rupees. Companies Act prohibit. Companies Act prohibit. Companies Act prohibit. There is one section 5353. We will study in the share capital chapter. There is one section 5353 which says that a company cannot issue shares at discount. Companies Act don't allow it. Now, if we are making a company Yeshas Academy Limited, in our article, can we write our company Yeshas Academy Limited will issue shares at discount? Can we write? No, because it is against Companies Act. So you have to follow Companies Act. So out of three, Companies Act, MOA, which document is the most supreme? Companies Act. In MOA also, you cannot write anything which is violating Companies Act. So out of all three, who's the most supreme? Companies Act, which means MOA and AOA both should not be contradictory to Companies Act. After Companies Act, MOA, which means MOA, in AOA you cannot write anything which is contradictory to MOA, and thereafter MOA. So if you see the importance, the most supreme is Companies Act, after that MOA, and after that AOA. Are we clear with this? So we have totally understood what is MOA and what is AOA. Difference between MOA AOA is there in your notes. I will show you. Remind me. You take you take the photo of that and you read it and come. Difference between MOA and AOA. Everything is done. Same thing is written. The difference between, you go through it on your own. One small point. Some case laws, 2-3 case laws are given. Why article is subordinate to MOA and how article is subordinate to memorandum. So 2-3 case laws are given here. 2 case laws. We will discuss these 2 case laws. How article is subordinate to MOA and why. So there are some cases which proves that yes, article is subordinate to MOA and MOA is supreme to article. What are those case laws? Come here. The article of the company are subordinate to and subject to memorandum, which means who's supreme? AOA or MOA? MOA is supreme. And any clause in the article which is beyond the memorandum will be ultra vires. For example, MOA does not allow you to issue shares. Now, if in article you will write how to issue shares, that will be ultra virus because it is beyond the power of MOA. So any clause in the article, clause means any provision in the article which is beyond the MOA will be known as ultra virus. Will it be valid? No, it will not be valid. But if the articles are only internal regulations over which the members have full control and may alter it according to their think fit. Remember, we did alteration of MOA. And don't you think alteration of MOA is a bit tough? Because everywhere we need ROC approval. Government approval we didn't in name, and there so we need RD approval also in registered office clause, and we need to pass special resolution. So when you want to alter MOA now, you also need government approval. There is a concept of RD approval, ROC approval also. So obviously you will take shareholders approval by way of SR, but also you have to take government approval, so that process becomes a little hectic and little painful. But when we talk about article is complete internal. It is our personal matter. It is our internal matter. How we are going to follow our internal procedures. So this is something which will be completely decided by the shareholders. So if we want to alter the article, we only need to pass special resolution. We don't need any government approval. You don't need any government approval for altering the article. It's like you are altering your internal rules and regulation now. So who can do that? Shareholders can do that by passing SR. You don't need to take any government approval for altering AOA. We will do this tomorrow, alteration of AOA. There we will study that how you can alter AOA simply by passing SR. Simply by passing SR, you can alter the AOA. So here one point is given ki since article are the internal rules and regulations, so shareholders have full control over it, and shareholders may alter it from time to time. And article that go beyond company's sphere of action. Company's sphere of action means scope of action. Scope. If article will write something which is beyond the scope of MOA, then it will be inoperative. Inoperative means invalid, and anything done under the authority of article is void and incapable of being ratified. So anything done which is as per article but it is not permitted in MOA, then it will be null and void, and it will be not capable of ratification. Means shareholders, even after 100% shareholders agree, then also they cannot approve that act. They cannot ratify that act. They cannot correct that act. That act will be null and void forever and forever, because it is beyond MOA, because it is beyond the power of MOA. It is ultra virus. So this proves that articles are subordinate to MOA and MOA is supreme to article. One more case law we will do. The functions of article in relation to the memorandum has already been summed up in the case of Ashbury case. There is one case of Ashbury railway carriage. We will do this tomorrow in doctrine of constructive notice. There we will do. One concept is given here. Even if article are subordinate to memorandum, we know that if we have to prioritize, we will give more priority to MOA. MOA is more important than AOA. But if there is any ambiguity, ambiguity means confusion. If there is any confusion in MOA, then article may be read to explain it but not to extend the objects. What does this mean? This means that if anything is not permitted in MOA, can we write that in AOA? No, because MOA is supreme. AOA is subordinate to MOA. But if there is confusion in the MOA, power is there, but there is confusion in interpretation, then we can use article to interpret it. For example, MOA permits that company can issue shares. MOA permits. I'm giving you example. Listen to the example. There is one document called MOA. In MOA, permission is given that company can issue shares. Permission is given to issue shares? Yes. Now can we prescribe the procedure to issue shares in article? Yes. Now there is one confusion. Which type of share they have not mentioned? Can company issue DVRs, differential voting right shares? Can company issue bonus shares? Can company issue right shares? Not mentioned. But power is given, company can issue shares. So there's confusion. There's confusion. Power is there, but there is ambiguity. Power is there in MOA, but there is ambiguity in MOA. Ambiguity means something is missing, or let's say ambiguity or confusion is there. So we can read MOA to remove that confusion, to interpret it. So if AOA allows, company can issue differential voting right shares also, bonus shares also, right shares also. Then we can issue DVRs, we can issue bonus share, we can issue right shares. which means we are not exceeding the power of MOA. MOA mein power is given, but since meaning is not clear, so we are getting a clear meaning by reading the MOA. So MOA tells you company can issue shares. Now AOA tells you how company can issue differential voting right shares, bonus shares, right shares. So this clarity is given in AOA. So by reading MOA and AOA together, we can say that yes, company can issue all the types of shares. Company can issue this also, this also, this also, all the types of shares. So we will read MOA as in MOA it is given company can issue shares. So we will read yes, MOA is trying to say company can issue all shares. How we will interpret this? By reading AOA. So वैसे तो AOA is subordinate to MOA. But if there is any confusion in the MOA, then we can read AOA and we can interpret it accordingly. We can use AOA to interpret the MOA. Are we clear with this? So here one point is given ki even though articles are subordinate to memorandum, but still if there is ambiguity in the memorandum, then article may be used to explain the memorandum, but not to extend the object. We can use article just to explain the meaning of memorandum, but not exceed the object, but not go ultra virus. Okay, that's all about discussing that AOA is subordinate. And there is one case of South Durham Brewery Company, brewery company. The memorandum of the company was not clear as to which class of shares can be issued, but the article made it clear by issuing different classes of shares. Same example is given here, that memorandum may power to issue share was there, but there was confusion, clarity was not there which type of share. So clarity was given in article was given clarity, this kind of shares we can issue. So here we can use article to interpret the MOA. So are we clear with the basic difference between MOA and AOA? Now, one more paragraph is there regarding article. We will do that and then we will end today's session. Before that, and the next section will be section 6. This we will do tomorrow. From section 6 we'll be doing tomorrow. Small points about article. Remember section 7? Section 7 talks about just 5 minutes, 5 more minutes. This is something which is already done, same as MOA that we studied, because see, we have done 90% portion of article. For this one, just why to leave this last one topic of article when we have done 90% topic of article? Why to leave this last 10% topic of article? So let's just complete this topic, and tomorrow we will start section section 6. Are we clear with this, everyone? Just 5 more minutes. Trust me, this you already know. Table FGHIJ you already know. That's all is given here, that we have to register the article. There is nothing new in this paragraph. We just have to read it. 5 more minutes only. So section 7 we have already done. Section 7 says that whenever you want to incorporate a new company, you have to prepare 2 most important documents of the company, MOA and AOA, and you have to register it with ROC. Without MOA, AOA, can you incorporate a company? No. So this is repeated. We already know this. Section 7 says that at the time of incorporation, when you are incorporating a new company, company has to file with the ROC a copy of MOA and AOA, which should be duly signed by the subscribers. We already know that MOA AOA has to be signed by the subscriber. Repeated? Yes. Next, the article of the company should be in one of the respective form, table FGHIJ for the respective company. Now, what is which table is applicable? Just like MOA. MOA का form was ABCDE. Similarly, article का form is FGHIJ for company limited by shares, company limited by guarantee, not having share capital, company limited by guarantee, having share capital, unlimited, not having share capital, and unlimited, having share capital. Okay, but wait, there is a small difference. You just have to shuffle these two. In article now, first table G talks about limited by guarantee having share capital, and then not having share capital, and then here also first we talk about having share capital and not having share capital. Are you understanding? So in MOA के form में first we were talking about limited by guarantee, not having share capital, and then having. Here in article, first form G is of having share capital and then not having share capital. Can you remember this? Yes. So you have to adopt respective form FGHIJ, whichever is applicable to your company, which is given in schedule 1. In schedule 1, all these forms are given: A, B, C, D, E, FGHIJ. A, B, C, D is of MOA, FGHIJ is of AOA. Next, a company may adopt all or any of the regulation mentioned in the model article. Model article means tables. FGHIJ. Now, guys, is it compulsory to adopt table FGHIJ? No. Can we make our own article? Yes. May. May means optional. May means optional. But do you remember MOA? ABCDE. Was it compulsory to adopt ABCDE? Yes, whichever is applicable to you. Guys, this is the main difference. MOA may it was compulsory to adopt either A, B, C, D, E, whichever is applicable to you. But AOA may it is not compulsory to adopt table FGHIJ. You can make your own article. So that's why the word used here is may. But in MOA, the word used was shall. Okay, so the company may adopt all or any of the regulation contained in the model articles. We may adopt the model articles, we may not adopt the model articles, or we may adopt only some regulations of the model article. So we may adopt any of the regulation. If we want to adopt only 2-3 regulation, few regulation of model article, then we can do that also. Now there is section 5. Section 5 talks about article of association, which says that a public company which is limited by shares may at its own option, may means optional, register its article signed by the same subscribers of memorandum. We already know subscribers of memorandum also have to sign AOA. Or we may adopt the regulations contained in table F if it is limited by share. If 99% companies are limited by shares. So if you are making company limited by shares, you have two option. You have two option. If you are making limited by share, you may make your own article or you may adopt table F. You have two options. You can either make your own article and register it with ROC, or you can adopt table F. Are we clear with this? Next, in article of private company, there are 3 restrictions as per section 268. Ring a bell, ring a bell, ring a bell. Guys, section 268, remember? In article of private company, there are 3 restrictions. So in every private company ke article, you will find those 3 restrictions. Remember? Restriction on transfer of shares, maximum number of member 200, and prohibition on public invitation. Next, nothing contained in section 5 will apply to article of company registered under any previous company law, which means if your article is made as per old Companies Act 1956 Act, then this section 5 will not apply. Okay, and last point, if the articles are not registered, then automatically table F will be applied. If you have not made your own article, then automatically table F will apply to every company. Automatically every company ko table F will apply. Every company has to follow table F. And if registered, then table F would apply insofar as it is table F will apply except if it is excluded or modified by the articles. To avoid any confusion, normally every public company delivers their own article along with the memorandum, and it would specifically stated that table F would not apply. Just one last point, please understand. There is one table F given. In table F, model articles are given. Model articles. Let's say how you will issue shares, how you will appoint directors, process, how you will issue shares, process, how you will appoint director. For example, how you will declare dividend, provide dividend, etc. etc. Just giving some example. Now let's say we are making a new company, Yeshas Academy Limited. So we have to make our article. Okay. So let's say if we have not made our own article, then for all the provisions, automatically table F will apply to us. Okay. Now let's say we have made our own article, but in our article, we have specifically prescribed the process to issue shares. We have also prescribed the process to appoint directors, but we have not mentioned anything about the dividend. We have not mentioned anything about the dividend. Then, for process of dividend, automatically table F will apply. Are you understanding? Even if we have made our own article, then also table F will also apply to us. But if we have made our own provision for some matter, for that table F will not apply, which means let's say for issue shares, we have made our own regulation, then table F will not apply for that. But for issuing dividend, we have not made any regulation, then table F will apply for that. Are you understanding? So for issuing dividend, we have not made our own article, then we will issue dividend as per table F, then table F will applicable. But if let's say our company, we don't want to follow table F, then in top of the article, we have to specifically mention we will not follow table F, or the company expressly exclude. The word used is expressly exclude table F. So when you write these words in your article now, then never ever ever table F will apply to your company. Only if you write these words in your article. If in your article you specifically write table F will not apply, or our company expressly exclude table F, then never ever ever table F will not apply to your company. But if these sentence you have not written, and even if you have made your own article, then also table F will apply for those provisions for which you have not given anything in your own article. For example, for issuing dividend, for declaring dividend, you have not mentioned anything in your own article, then for that purpose table F will apply. For that purpose table F will apply. But even in that case, table F will not apply if you have expressly mentioned it in the here. In the article, you have expressly excluded the table F. Are you understanding, everyone? That's all about article of association. Are you able to understand? Pakka? Pinky promise? Okay. This is all about article of association. So we are done with section 4 and section 5. Tomorrow we will do section 6. Section 7 we have already done, and we will do alteration of article, and also we will do all the doctrines of ultravirus, and tomorrow we will complete this lesson and we will move towards another lesson. Okay, everyone? Just a second. I wanted to discuss one question. Ma'am, see our faces. Next Sunday, we will have extra classes next Sunday. Okay? This Sunday, I'm leaving you. Yeah. Next Sunday, we will have lunch break and we'll have extra sessions after the break. Okay? Yes? Okay. So today, I'm leaving you. Tomorrow, we'll complete this lesson and we'll do some questions of this lesson. Okay? So what you have to do, you have to properly go through the notes and the material and properly learn about what is MOA, what is AOA, all the clauses of MOA, and alteration of all the clauses of MOA. Whatever we have done till now, you have to properly learn and come. Tomorrow there will be oral test. There'll be oral test of MOA, AOA, all the topics that we have done till now. Trust me, this lesson is going to be more complicated tomorrow. Tomorrow the topics are more complicated, the remaining topics of this lesson. So for that, you must revise and come what we have studied till now, so that tomorrow's topic will be easier for you. Tomorrow's topic are a little, very much intense topics are there. So for that, it is important for you to revise and come. Revise what we studied today and then only come tomorrow. And learn also. Revise and properly learn all the topics. Pinky promise? Everyone? Oral test will be there. Properly learn and come. Notes are there. I've sent it in the group. Everything you have to go through and come and learn and come. Okay. That's it for today. Thank you for your patience. Thank you for your time. And see you all tomorrow. Please revise and come. Keep learning. Keep growing. Take care. Bye bye. Online students, see you tomorrow. Take care.